YouTube. Good morning. Hello. All right, give it a second to get things going here. How's everybody doing? It's early on Sunday. All right, it's very early Sunday. I think that is an understatement. All right, it's early. My name is Grant Smith Ellis. We'll give things a second to get going here. It is a little bit rainy here, so we'll give it a second. It's going to buffer for a second before it really gets going. But that's all right. I'm glad to be with you. As I mentioned, my name is Grant Smith Ellis. Yeah, there we go. All right, let's roll the intro.
Hold on. Wait a second. That's it. That's it? Yeah, that's the melody to Funky Town.
You heard the little towel. Good morning. Look at me. I'm a little towel. I'm in my collared shirt. And my phone is working. Excellent. All right. How's everybody doing? It's a relaxing Sunday morning. I'm going to say this phrase, but it's going to doom me. It's going to be a short stream. All right, we're going to play some trivia. We're going to go over this filing, talk a little bit about the developments. Good morning. Nice to see you, Benny. Talk about the developments over the past 10 days. We didn't actually get through it, all right, because I think a lot of things make sense right now in context, all right? Few prefatory remarks. Prefatory? I think that works. One, I've seen everything under the sun at this point, all right? No tactics are going to work on me. Don't even bother, all right? Like, don't bother. Especially at this moment of all moments. Second of all, here's what I think's going on, all right? We're at a place now. We're at an inflection point, all right, with the way all of this ties together. And it is very political, all right? It involves the Norfolk DA's office. It involves a number of things, all right? But we're going to try to break it down. Now, the reason, of course, so they say the early towel gets the worm. It's a little true today, okay? Why is there a midnight filing in the John O'Keefe and Karen Reed civil case on a Saturday? Yes, you can docket ECF filings anytime, okay? You don't have to go into court. This was a weird one, though. All right, we got this filing overnight, attempt by some of the, what I would call Canton aristocracy, trying to block Karen Reed's cross-complaint. Hi, Nunya. I'm thrilled that you have a collared shirt on. It is a collared shirt kind of day. That's also why we're going to try to keep things short, because it is Sunday. I don't necessarily love streaming on Sunday, but one, we didn't get through everything yesterday. We had a lot to get through, and so we have more things to talk about. And two, I wake up this morning, I'm just being a little towel. Now, first of all, I see that crusty, the word crusty is trending on Twitter. I just combined those two words. That's kind of funny. Needless to say, I see the word crusty trending on Twitter. I started laughing. Just laughing. All right? Just laughing hilariously. And then I'm like, okay, I got to find out what that's about. Before I can even find out what that's about, somebody, one of the, I don't know if it was Dee Dee or one of the accounts, posts this filing. Now, I'm like, oh, it's like 4 a.m. or something when I get up, and I had been sleeping since like 7, and there was nothing really going on overnight that was relevant. So I was like, all right, I'll just go to bed. And I wake up, and I couldn't conceptualize why there was a new filing when I was waking up at 4 a.m. on a Sunday. I was like, I am going to play a little trivia today. We're going to like catch up on the week. Then I'm kind of like, what do you mean there's a new filing? It's midnight. That's when this was posted. It's midnight on a Saturday. So, hello. Good morning, Nancy. Good to see you. But yeah, so I wake up, and those of you who are up, I'm not saying everybody's an early bird, but if you're an early towel, you're getting the worm today, because most people are, first of all, were asleep when this hit the docket or hit the social media. And second of all, you don't expect filings like this on the weekend, all right? So we're going to read through this. I have not read it. We're going to hear it read out loud. I'm going to listen to it with you. Those of you just joining in, you are not like disorientated. You are not daydreaming. Just when you thought there was a lull in the action as we await to see what happens with some of the cacophony of chaos related to the Norfolk DA's office, the Cape Peter criminal felony cases, why there's been no response from the Norfolk district attorney's office in the Aidan Kearney cases. All of this is going on simultaneously. All right, information dropping left and right about Kate Peters' ex parte contact with the Norfolk DA and how that ties in to the wider picture. A lot of subterfuge going on. Right, so as all of this is going on, you think you're going to get a little bit of lull. There's not much going on, as I mentioned, overnight. Then you wake up, and no, you are not daydreaming. You are lucid. There was a court filing that was posted at 12 in the morning on a Sunday. God bless America. God bless us all. 12 in the morning, out of nowhere. So yes, it took me like 2 hours to kind of come into it and be like, what is going on? What do you mean there was a court filing? So we're going to read it. Now, here we go. This is what we're going to do. If you didn't see it yet, if you're just tuning in, I was giving folks a little bit of time to get caught up. There was a court filing from the Canton aristocracy, all right, who are also raising money. I'm not really sure if there's disclosure of where this money is going or who's running it. And Kate Peters seems to be involved. I'm very baffled by the whole thing, despite everything going on. I'm just baffled. But anyway, no rest for the weary, no lull, no time off or time to relax, just immediately into a court filing. And this is a non-party motion to oppose Karen's cross-complaint. Now, a little background here. What you had, right, was John O'Keefe and the estate of John O'Keefe and John's family filing a civil complaint against Karen Reed in Plymouth Superior Court. Then what happened was, and we're not going to go into all of the procedure and the motions to dismiss and whatever. We're not going to deal with that right now. We'll come back to it. But then about like 6 months later, no, more like 12 to 18 months later, Karen goes to Bristol Superior Court and files a civil lawsuit against like the state police. Well, she hasn't brought them in, but it's going to be against the state police, the town of Canton, Michael Proctor, Brian Tully, Yuri Buchanan, Jen McCabe, Matt McCabe, Brian Higgins, Brian Albert, Nicole Albert, and I think that might be it. But the point is, Karen files this complaint, okay, in Bristol Superior Court. But then you have two simultaneous cases going on. Now, I'm not a lawyer, this is not legal advice. But then procedurally, where we were at is there was a hearing, if you missed it on Friday, we've watched it twice on this stream over the past few days, in the civil case. And it was only 15 minutes long. They didn't really talk about very much. It was very rapid. I guess it was substantive if you understand the rules of civil procedure, but it wasn't really substantive unless you really knew what they were saying, and then they weren't really talking about things that were that material. They weren't arguing motions. They were doing like timetable setting for potential future motions and etc. So the point and discovery issues, and is then one of the issues they were talking about was service of Karen's Bristol complaint on the defendants in that case, because in one of the footnotes, Karen noted that for at least discovery purposes, she wanted to combine the lawsuits. She wanted to move the case she filed in Bristol over to Plymouth, which is kind of ingenuitive because it means like even if the motion to add these cases together, which some of the lawyers that we're talking about doing for discovery purposes, but even if they don't get tried together, it's actually kind of ingenuitive. Hold on a second. Drop my bottle cap. It's kind of ingenuitive because what Karen did was she created an independent civil cause of action in Bristol, okay, independent of the Plymouth case. So whether or not this motion, which we're going to read, this motion has to do with she's trying to, in essence, by combining the cases, Karen is adding third-party defendants to the Plymouth case. And this is a motion to oppose that. Now, whether the cases get consolidated or not, it's kind of immaterial to whether Karen's cause of action in Bristol will move forward. It can just move forward. But what I think Karen's banking on, and this kind of makes sense, is that it doesn't really matter what the third-party defendants wants. They're really defendants in the Bristol case, but potential cross-complaint defendants in the Plymouth case. It doesn't really matter what they want. What the courts are going to think about, in my opinion, as a layperson, not a lawyer, this is not legal advice, is judicial economy. It's a civil case. You're not going to have parallel proceedings that touch on similar operative facts. You're going to have two judges, two juries, two stenographers, two Courtrooms, it's an incredible waste. And if you know the way the civil court process works, judicial economy is everything. You're not wasting court resources to have the same operative matter tried in 2 different places. Not happening. So that's why, whether or not you have to overcome the hurdle of the nexus. I'm not a lawyer, this is not legal advice, but I'm just previewing what we're going to read about. You have to overcome this hurdle that if there's a nexus of facts that link the causes of action, and there's a very broad conception of nexus of operative facts because there's something called a causal chain for civil liability. Again, I'm not a lawyer, this is not legal advice, but let's all at least understand what we're talking about. So, what we're talking about is there's a causal chain in civil cases. So when I say operative facts, literally you have to think of the world of everything related to the causal chain. What is a causal chain? Oh, dear goodness. All right, how do we explain this? Okay, so this is a lay explanation. I'm not a lawyer, this is not legal advice. A causal chain is like... I haven't done this in a while. All right, so... A train is driving on the train tracks, okay? One of its brakes is faulty, okay? It comes into a station, and then it wobbles, and a big box on the top of the train falls off and hits someone. The causal chain as to who is responsible for the box falling on the person goes all the way back to whether, like, the train was properly inspected, whether the company appropriately purchased the parts for the train, whether they were keeping up with the industry standards for maintenance on the train. That's a causal chain. You would not think like, oh, the whether or not the company like did maintenance on its wheel impacts the crate falling off like 1,000 miles away from its facility at a station because the train wobbled. It does. It's kind of akin to if you get your car inspected, okay, and there's an obvious fault at the time of the inspection and they pass you anyway, and then you go out on the road and you crash because there was a fault that was missed during the inspection and the person who was hurt because of the crash can prove it. That's another example of a causal chain. You wouldn't think that because your car's messed up and you're out on the road that the person who inspected your car when it was in that condition and passed you anyway has liability. They do. I'm not a lawyer. This is not legal advice. Hello, LS. So we have to think about all of that. Okay, this is prefatory remarks. I have not read this motion, but you've got to... The hurdle that these defendants have to overcome is twofold. One, they have to get over this initial barrier. They have to make the argument that there's no nexus in anywhere in the causal chain between what Karen is alleging in her Bristol complaint and what's going on in Plymouth. Even if they make that argument, they still then have to argue that judicial economy, and there's scarce judicial resources. You have to understand how much the courts think about this. How much judicial economy is impacted if these two cases go along simultaneously. Karen has a right to file an independent cause of action in Bristol, whether or not the cases get combined. So really it's a question of the court's resources, and that's what we have to read about. So, here we go. But yeah, no, I absolutely think there are a lot of smears and lies being spread right now. I think a lot of people are close to Marty Kraft. Whether Benny is close to the PI Marty Kraft or Kate, I don't know. But yeah, Benny, if you want me to address it, my response is it's a smear, it's fake, it's designed to tactically induce very specific results, all of which failed, and I don't know, Kate sucks. Anyway, Benny, it's fine that you're here, but don't gaslight me. Come on. Don't play the game. Just say outright that you're connected to Kate Peter. I saw you at the hearing with her, right? I know your style. All right? I only ask questions I know the answer to. So you want me to flip it around, Benny? No. There will be no conversation between you and I because I know that you report to Kate Peter. You're a lackey. All right? So come to terms with it. All right? Just embrace it. All right? Hey, you brought this upon yourself, all right? That's what I said. Like, don't run an op on me. Are you out of your mind? I'm 42 steps ahead of you. I use that number on purpose. You got to read Hitchhiker's Guide to the Galaxy, which features towels, by the way. Why even bother? He didn't, Shannon. That's what I'm saying. It's this Kate Peter narrative that started as a smear in her Discord because documentation came out that Kate and all her people had, especially Kate, had direct contact with Michael Morrissey, the Norfolk DA, as well as Brian Tully and others. And Michael Morrissey was stupid enough to send himself an email with a Discord attachment that had a server ID that he didn't realize directly linked to Kate Peters' private Discord server, which also had members of and witnesses involved in both Karen Reed and Aiden Turtleboy Kearney's cases. So that's what I'm saying. Like, I get what people are really concerned about coming out, but please, like, don't disrespect, one, my intelligence. And I'm not being pedantic here. Don't disrespect my intelligence. Two, don't assume what I know. All right? That's a very bad idea. Okay? Because I don't talk about most of what I know. I'm a reporter. Come on. Third of all, there's no reason to gaslight me. I hate it. I hate it. Just be straight up or don't bother. Like, look at the people in this chat, okay? These are people who have been here for a while. You don't just come in here, right? Like, it doesn't, you don't come in here and gaslight because you don't want to talk about Kate Peters' connection to the Norfolk DA, all right? Because that'll make me want to talk about it. So don't do it. Don't bother. Either come straight out and talk about your connection to her, Benny, or in the chat, or don't bother. But yeah, I'm glad I was able to address that. Thank you very much for your question, Benny. And in short, let me actually play a video. You know what? I want to play a video for Benny. Benny, this is a very special video for you. All right? Now, if you haven't seen this before, all right, I've played this before. It's a former FBI agent who does contract work for the CIA. He was caught by an undercover journalist. And I want to show this video because I think, one, I don't think I'm going to ever decondition Benny, because you can't decondition someone who is being intentionally subversive. But I want to play this video because I think it's a very, very, very good commentary on exactly the operation we saw ran over the past few days. And Benny wanted my response, so I'm going to respond in video format with this clip, this excellent undercover clip, all right, because I'm a journalist. And I like when other journalists do the legwork, all right? So this is a clip from, I forget the agent's name. I'm going to bring the clip up here. Hold on, I have it. I posted it at some point recently to make this exact point, Benny. So I actually want to thank Benny, regardless of his motives, because he reminded me about this clip, and this is exactly the op that was ran over the past few days. Benny, God bless you. I actually needed to be able to bring up this clip. It is from, where am I going to say? I just got to remember what I posted it under. Hold on. We're watching this clip come hell or high water. What did I post it under? I got to remember. Maybe I used the word like tactics. Yeah, I think I used the word tactics in the post, okay? So that's how I'm going to find it. Now, Benny, you got to pay attention. I want you to get your notepad out. All right, get your little towel notepad out. You're gonna your towel in training. All right, whether you can be deconditioned or not, and we're going to take notes on this. All right, this is a very important little video here. No, that's not it. Where is it? Come on now. All right. Honey pot. Hold on. I'm not going to give up that easily. I know I have it. What did he say in the beginning? Oh, like a bump. I think I called it like a bump or something, because it kind of is like a bump. I got it! I found it! Benny, God bless you. You're going to be so pleased that I found this. Oh, I'm so excited for you. All right, ready? Well, I'm excited for me, too, but look at this. All right, now tell me if this doesn't sound similar to exactly what we've seen over the past few days. So I want us all to put on our little towel hats. All right, we'll embrace our inner Auntie Deb. All right, everybody get ready to learn. Now, Benny, this is for you. I'm playing this video so you understand that this is exactly what played out over the last few days. And although I know you already know that, I'm actually speaking to the other people who are listening to our conversation as a kind of didactic learning experience. And you brought this upon yourself. Just remember that, all right? Just get a tattoo, or Kate Peter can get a tattoo that says, I brought this upon myself, remember that.
You can kind of put anyone in jail if you know what to do.
How?
You set them up. You create the situation to where they have no choice but to act on their impulse. And once they act on that impulse, then we call that entrapment. We call it a nudge.
A nudge.
A nudge. Sometimes you just gotta give them a quick little, just to see what happens, right?
And how does that happen?
You put a post out there, or you have someone fake profile say something that triggers, that we know is going to trigger them, right? Like, we already know your history. If we're to that point, we already know everything about it. So we're like, oh, this will piss them off. Sometimes you light the fuse and just wait for it to follow. Nothing like putting out a fake social media thing to like really get people mad. Oh, it's fake news. Sometimes it's not fake. It's embellished a little bit.
There you go. So, there you go. I'm glad we all took notes, and that is exactly what has been happening. Actually, you know what? Let me repost this right now, because Benny inspired me to repost this. This entirely slipped my mind. I forgot that there's a video out there where a former high-level intel operative talks about planting fake information on social media for the purposes of inducing a reaction in their targets. Wow! What a coincidence! Sorry about that. Benny, I'm so... And then I dropped my keyboard. Benny, I'm so grateful that you helped me remember that. You know, if you Benny, if you go to bed tonight thinking about what you did for the world, I just want you to remember that you helped me find that video, even though I had posted it myself, and bring it back to the public's attention. So just, you know, whether you're on Discord or whatever, just tell your people to tell their people that it was you. Just like Kate Peter was the one who introduced me to Lindsay, to her very much regret, almost immediately. You, Benny Blanco, helped me put this all together and reminded me of what's really going on. Look at that, a noble service to the towel people. Yeah, no, but Christina, it's kind of like denying the antecedent. When you put, that was why I was playing that video. When you put information out there that's false, no one can disprove a negative. It's a smear tactic designed to induce a reaction. So I was telling Benny, it's not the lie, it's the intended reaction in the target because of the lie. That's why I'm flexing on him a little bit, you know? Sometimes you just gotta flex on the bastards, all right? It's a little flexing, all right? I'm not saying I'm going full flex, all right? I haven't gone to the State House fully yet as to my special prosecutor reform bill, okay? But it's a little flex, all right? Sometimes you just gotta flex on them. Sometimes it's as simple as a smile. Isn't it? Isn't it? Benny went oddly quiet. I just wanted to know if he talks to Kate Peter. Can't really deny it because I have video of him walking into court with her. Hey, you all brought this upon yourselves, all right? The people who thought that they wanted to engage in a political war, and then Adam Deutsch announced his candidacy for Norfolk DA. Listen, these people are in an apoplectic state of chaos. Lies everywhere right now. It's actually very telling because it helps me understand how desperate they are. Like the number of different lies they use as an indication of what they're trying to avoid. So LS is like, Grant is on one. I absolutely am, LS. I've been having a Sunday. All right, we're ready to read this. Let's do it. Let me make a post about it as I read it. All right, that was a good intro. That was fun. Thank you for that, Benny. I needed that this morning. I am already in a good mood. You put me in a better mood. All right. I am reading the new midnight filing from the John O'Keefe and Karen Reed civil case. Totally normal for this to come out at 12 a.m. Eastern on a Sunday. Totally normal. Totally normal. The Canton aristocracy moves in mysterious ways. I think that's a very true statement. People want to call them the House defendants. Bro, just call them the Canton aristocracy, okay? Because it makes their whole farce of a fundraiser, in my opinion, look as the farce that it is, all right? I also want to know what Benny knows about Mike Gaffney and Kate Peter intentionally sabotaging one of Lindsey's fundraisers, but, he's never going to be forthcoming anyway. Won't even admit to his ties to Kate Peter. See what I'm saying? Sometimes you just got to call them out, rile them up a little bit. Where'd I learn that tactic? Oh, my goodness, it's Bossy Texas Chicken Bella. Bossy Texas Chicken Bella. Bella, listen, we had a 12 a.m. midnight filing. It was like the Saturday Night Massacre with Nixon, but even worse. I don't even know how it's possible. How do you do this at 12 a.m.? How do you file something, whether it's with the other side or whatever, at 12 a.m. on a Sunday? It was so weirdly timed, too, because it was during such a lull. Like, there wasn't really much going on. There was a lot of, like, pressure tactics to get, like, people to respond emotionally to lies and smears, which is normally a sign that something big is coming. But even this isn't what's coming. There's something coming, and it has to do with the cloud of protection afforded to the people in the orbit of the Norfolk DA falling away. I don't know. Now, the other weird thing was, like, but for the special assignment of the civil case in Plymouth, folks, the judge would have been Judge Cannoni the other day. That was even more interesting. Bossy Texas Chick, I don't even know what to say with this 12 a.m. filing. Like, especially, like, you can tell things are at a lull but crescendoing, as I mentioned, when we see the kind of tactics like we just watched in that video from the former FBI and CIA operative talking about intentionally spreading false information on social media that can't be disproven or proven for the purposes not of the merit or substance of the false statement, but to induce an emotional reaction in the target for the purposes of then acting on that reaction. When that's going on, it's because there's a lull leading up to something. This 12 a.m. filing, folks, absolutely abnormal in so many ways. You never see it. You see it in federal court sometimes. You also see like 8 p.m. hearings in federal court because it's open 24/7. Very odd, okay, for it to come out at midnight, especially, like, as I mentioned, on a Saturday, where most of what's going on is kind of a harbinger of stuff to come. For this to happen, too, it just makes me think it's also kind of an indicator that something is coming. And I can't put it all together, okay? I've tried so hard with my chat, okay? I even have a chart. Do you understand what it means when the man with the chat can't tell you where this is going? We're going to read the filing, but I thought I had it all put together. But there's something about the feds and Farwell and Birchmore and the open IA investigations of multiple troopers and the leak of Lindsey's phone extraction and the intel tactics and Marty Kraft as the PI and Kate Peter and the people in her orbit and all these, like, weird moles that worked for, like, years to get close to people. Bro, that's some high-level stuff, all right? That I can track it. I have some idea of what's going on. I can call it the nonsense. The way I'm able to do it is I don't think you all realize I'm not very well physically, so I have to lay down a lot. I just read, okay? That my eye isn't great, but I can just read or listen if I have a text-to-speech program if I need it, which I use a lot. Where do you think I found these things? Because I have trouble reading a lot because of my eye. But my optic nerve is not great. But my point is, I have enough of an understanding to have tracked where this has come to at this point. But I myself cannot tell you where it's going. I know that it's big. I know that it has to involve, like, this tension. I think the DOJ doesn't love prosecuting cops right now, based on what I understand. And I think that ties into why U.S. Attorney Foley was so comfortable having the Canton Police and Hank Brennan and the Walsh prosecutors announce the end of the federal probe into John's death, although that probe had ended a while back. Because I think there's a political question about how to hold this unit, Brian Tully State Police Unit, accountable. This filing, I don't think, I haven't read it yet, but I don't think it's the big news. I think the timing of it, the way it's dropping, there's something going to happen soon that is not good for the people in the orbit of Kate Peter, the Norfolk DA, whatever. And I don't know what it is. And I've always felt that it wasn't necessarily what happened on the night of January 28th and January 29th. It was kind of like the book Midnight in Savannah. I've always felt this, like from Midnight in the Garden of Good and Evil, okay, which is about murder in Savannah in the 80s. A good documentary, too. I always felt it was like that. Like, yes, there was a very serious loss of life, and God rest John O'Keefe's soul. But there was something about these people. Like, this town, this ostensibly sleepy little town, that was really so much more. And it was about the secrets that lay beneath. It was about what Karen knew about what those people in the house like did socially. It was what they knew about what Karen and John were like. It was about a lot of people who knew a lot of things that shouldn't have become public, or they didn't want public. Now, I don't know tactically exactly how this all played out. I have some sense of it because I lived it. I didn't mean to. Bro, I did not mean to live this. I've talked about this before. It was an accident. It was just a Brian Riccio posting about Turtle Boy, and my friend talking down the Cape one day while I was sitting on his porch about how Karen's route of travel was very complicated on the morning of January 29th. That's why I got interested in this. And then over 2.5 years, it inadvertently, I lived it, all right? And I understand the dynamics. And there's something about, there's like some unspoken tie between like this PI firm, Marty Kraft, and like, I'm going to be very gentle here, and like certain individuals who have been around either Turtle Boy or the Free Karen Reed movement for a long time, but weren't around them authentically. And those people, because they think that they're running ops to get people to emotionally react to them. But what's really happening is their ops are actually being kind of tracked in a larger picture as indications of what they're trying to hide. So you have to burn deep cover moles to run certain types of operations. And if you burn enough of them, then it allows your opposition or someone analyzing it to see who is working for who. They won't be saying it outright, but like it's the tone of the responses. It's like what they don't want to talk about, whatever. Like folks don't realize like there's a point to every exchange that I have, and I'm always trying to test out like what tone are you using, who are you allied with, who are you really working for, who are you pretending to work for. I do that with everyone, bar very few specific people, okay, who I trust. So I know what's going on. I have a full picture in my head, and I have almost put it all together, and I see what was lying beneath. I don't like it. I hate it, actually. It's really not cool. They may think it's cool. I don't think it's cool, bro. It's not cool. It's like, it's malicious. Like, if there were honor to it, I would be so much more deferential to the unspoken here, okay? But there's no honor in how some of this played out. There was no honor in the release of that phone extraction. There was no honor in how Karen was talked about. There was no honor in how some of those text messages were withheld from criminal defendants. There's no honor in it. Talk about fighting fire with fire all you want. There's no honor in some of the tactics that were used. Yeah, that was a fascinating response, Nunya, from the Post-Commission. All right, let's listen. On that note, we will play trivia after this document. So if you're tuning in for trivia, we are going to play trivia today, but I think I've laid down enough preface for us to read this document. I'm not saying there's going to be the be-all, end-all document or a bombshell, but the fact that it was filed at midnight on a Sunday is a little odd. All right, let's go.
1 Commonwealth of Massachusetts Plymouth, SS. Superior Court, C&C Hospitality, L. Non-parties Jennifer McCabe, Matthew McCabe, Nicole Albert, Brian Albert, and Brian Higgins as opposition to Karen Reed's motion to add parties pursuant to Mass. R. Civilian. P21 Non-parties and witnesses in the Commonwealth's prosecution of defendant Karen Reed, Jennifer McCabe, Miss McCabe, Matthew McCabe, Mr. McCabe, Nicole Albert, Miss Albert, Brian Albert, Mr. Albert, and Brian Higgins, Mr. Higgins, collectively, the Commonwealth witnesses, having been served by defendant Karen Reed, defendant Reed, with her motion for leave to add parties pursuant to Mass. R. Civilian. P21, the motion, along with a proposed cross-claim pleading, Proposed cross-claims, hereby write to the court to oppose the motion. Defendant Reed's proposed cross-claims and related factual allegations against the McCabe's, the Alberts, and Mr. Higgins are a vile work of fiction lacking any basis in fact, evidence, or law. Indeed, these outlandish allegations are part of Defendant Reed's scheme to defame and wrongly malign the Commonwealth witnesses to evade responsibility for her actions on the morning of the 29th of January, 2022 and for causing the death of Officer John J. O'Keefe, Officer O'Keefe. The Commonwealth witnesses vigorously dispute Defendant Reed's allegations and will defend against these false claims. The Commonwealth witnesses' defense will include motions to dismiss, potential removal of these claims to federal court, as well as counterclaims against Defendant Reed and third-party Aidan Cunny, Mr. Cunny, also known as Turtle Boy, for defamation and other torts that they have committed, individually and in concert. The Commonwealth witnesses, however, should not be forced to litigate these false allegations and their own defamation claims in this pending lawsuit, brought by the family of Officer O'Keefe against Defendant Reed and 2 other defendants for their role in causing the death of Officer O'Keefe on the 29th of January, 2022, the wrongful death action. Bringing Defendant Reed's proposed cross-claims into this action, along with the Commonwealth witnesses' defamation and other tort claims, is procedurally improper at this stage and will substantially increase the claims, parties, factual disputes, and legal questions in this case, without any evident economies of scale. Moreover, plaintiff's wrongful death action is currently past the motion to dismiss phase, with discovery having commenced. If Defendant Reed is permitted to file these claims relating to her criminal prosecution in this case, the motion practice on her pleadings will likely take months. Then, if Defendant Reed's proposed cross-claims survive dismissal, the Commonwealth witnesses will file their own counterclaims against Defendant Reed and Mr. Cunny in this action. Those counterclaims could, again, trigger months of motion practice. As such, the current discovery schedule could almost be over before the pleadings are closed on Defendant Reed's proposed expansion of this case. Accordingly, Defendant Reed's motion should be denied, and she should be directed to file her proposed pleading if at all in a separate action. In that separate action, depending on what claims survive dismissal, it may be appropriate for the parties to consolidate the cases pursuant to Rule 42 of the Massachusetts Rules of Civil Procedure. At this time, however, it is too early to determine whether judicial economy and efficiency could be served by consolidation in the future. Nevertheless, it is evident that there is no basis to warrant joinder at this time, and the present motion should be denied. Factual and procedural background as set forth in the plaintiff's complaint. On the evening of the 28th of January, 2022, Defendant Karen Reed consumed 9 alcoholic drinks during an approximately 3-hour period at 2 different restaurants prior to getting behind the wheel of her SUV with her boyfriend, Boston Police Officer John O'Keefe, 3. Campbell. 14 to 30. At that time, Defendant Reed was clearly intoxicated and unable to safely drive her vehicle. ID 29. Nevertheless, after a night of drinking, Defendant Reed drove Officer O'Keefe to Mr. and Miss Albert's home at 34 Fairview Road in Canton, Massachusetts. ID 30. After Officer O'Keefe got out of Defendant Reed's vehicle in front of the home, Defendant Reed hit him with her car while she was intoxicated as she left. Rather than stop, Defendant Reed left Officer O'Keefe lying seriously injured on the ground in front of 34 Fairview Road. Officer O'Keefe tragically died from the injuries he suffered when Defendant Reed struck him with her car. Campbell. 32 to 34. After hitting Officer O'Keefe, Defendant Reed then drove her vehicle to Officer O'Keefe's home. A few hours later, at approximately 4:30 a.m., Defendant Reed was frantic and woke up Officer O'Keefe's then 14-year-old niece and talked about how Officer O'Keefe was not home, that Officer O'Keefe may be dead, and that Defendant Reed may have hit Officer O'Keefe with her car. Campbell. 35-39. Defendant Reed arrived at 34 Fairview Road at around 6 a.m. Defendant Reed immediately spotted Officer O'Keefe in the area where her car had struck him a few hours earlier. Defendant Reed was hysterical. At the home, Defendant Reed repeatedly stated that she hit Officer O'Keefe. Campbell. 43 to 44. Defendant Reed never told anyone in January 2022 that she saw Officer O'Keefe enter the home at 34 Fairview Road. According to testimony at trial, shortly thereafter, Defendant Reed spoke to the police. Defendant Reed told the police that she did not see Officer O'Keefe enter the home at 34 Fairview Road. Similar to Defendant Reed, the police questioned each of the Commonwealth witnesses, and each told the police that Officer O'Keefe had never entered the home. A few days later, Defendant Reed was arrested for causing the death of Officer O'Keefe when she hit him with her car as she was drunk driving. Defendant Reed was eventually indicted by a grand jury and charged with second-degree murder and manslaughter in the death of Officer O'Keefe. In the spring of 2023, Defendant Reed, while awaiting trial, individually and in conjunction with third-party Aidan Kearney, embarked on a strategy to defame the McCabe's, the Alberts, and Mr. Higgins by falsely accusing them of, inter alia, murdering and /or covering up the murder of Officer O'Keefe. Defendant Reed did so to evade responsibility for causing the death of Officer O'Keefe by diverting attention from herself. As outlined in a police affidavit, Defendant Reed started to coordinate with Mr. Kearney in April 2023, initially using an intermediary to coordinate Mr. Kearney's public communications. Defendant Reed and Mr. Kearney also relied on the messaging app, Signal, to communicate and coordinate strategy. Defendant Reed's and Mr. Kearney's unlawful campaign, individually and collectively, to defame the Commonwealth witnesses has caused them substantial injury. In the spring of 2024, Defendant Reed stood trial at Norfolk Superior Court. Defendant Reed did not testify on her behalf at the trial. That trial ended in a mistrial due to a hung jury. In August 2024, the plaintiffs filed the present wrongful death action against Defendant Reed and other defendants. The court stayed this wrongful death case pending Defendant Reed's retrial. In the spring of 2025, Defendant Reed was retried. She again did not take the stand in her defense. The jury found that the government failed to meet its burden of proof on all counts, except the charge of operating a vehicle under the influence. After that verdict, this wrongful death action resumed. In August 2025, Defendant Reed moved to dismiss the complaint. In early October 2025, this court denied her motion to dismiss as to all counts except one. Then, on the 20th of October 2025, Defendant Reed answered the complaint. On the 28th of October 2025, Defendant Reed served this motion pursuant to Rule 21, governing misjoinder of parties, and asked this court to allow her to file a 9-count proposed cross-claim with a mix of state and federal causes of action against 10 new parties, including the Commonwealth witnesses. Argument I Rule 21 is not the proper vehicle for Defendant Reed to join the Commonwealth witnesses and assert the proposed cross-claims. As an initial matter, the present motion is procedurally deficient as Defendant Reed mistakenly brings her motion under Rule 21 of the Massachusetts Rules of Civil Procedure, which is not relevant to her proposal to add new cross-claim defendants and cross-claims related to her criminal prosecution to this wrongful death action. Rule 21 governs misjoinder of parties, and states, misjoinder of parties is not a ground for dismissing an action. On motion or on its own, the court may at any time, on just terms, add or drop a party. The court may also sever any claim against a party. See Mass. R. Civilian. P. 21. Under this rule, the court has the discretion to overcome a technical problem of misjoinder by adding the correct party or severing claims against a party. Palmer v. Murphy, 42 Mass. App. CT 334, 677 N.E.2D 247, 1997, see also Stock v. Massachusetts Hosp. SCH, 392 Mass. 205, 214, 467 N.E.2D 448, 1984, cert. Denied, 474 U.S. 844, 106 S.CT 132, 88 L.ED2D 109, 1985. Failure to join indispensable party does not require dismissal under Mass.R.Civilian.P19, A, or Mass.R.Civilian.P21. Perkins SCH for the blind v. rate setting common, 383 Mass. 825, 830, 423 N.E.2D 765, 1981, no abuse of discretion in allowing plaintiff, after hearing on the merits, to amend complaint to add the Commonwealth as an indispensable party defendant. Rule 21 is inapplicable here. Defendant Reed does not seek to cure a deficiency in the current pleadings. Instead, she seeks to add entirely new parties and subject them to entirely new claims surrounding not the circumstances of Officer O'Keefe's death but, rather, her own criminal investigation and prosecution. Indeed, Defendant Reed's citation to Kaiser found. Health Plan, Inc. v. Pfizer, Incorporated, in Re Neurontin MKTG and Sales Practices Litig. 810 F. Sup. 2D 366, 370-74, D. Mass 2011, in her motion highlights her misuse of Rule 21. In Re Neurontin MKTG and Sales Practice Litig, the court held that the regional subsidiaries of the Kaiser Foundation Health Plan could be added as plaintiffs pursuant to Rule 21 to the lawsuit after trial to avoid a standing challenge on damages. The court found that there was no prejudice to the defendant, Pfizer, by the Rule 21 joinder because Pfizer had the opportunity to fully litigate the damages associated with the subsidiaries throughout discovery and at trial. At 372-73. In other words, in Re Neurontin MKTG and Sales Practice Litig. Concerned a technical correction of the parties not claims in a case in which the parties had effectively litigated as if the new parties were always part of the lawsuit. That is not so here. Defendant Reed's proposed new pleading brings in new parties and new claims that are not part of the pending wrongful death action. While the wrongful death action and Defendant Reed's new pleading are broadly related to the tragic death of Officer O'Keefe, the wrongful death action directly addresses what happened to Officer O'Keefe the evening of the 29th of January, 2022, while Defendant Reed's proposed claims and allegations relate to the events that occurred after the death of Officer O'Keefe during her multi-year prosecution. Instead, Defendant Reed should have sought to amend her answer under Rule 15 and sought to join the new parties, including the Commonwealth witnesses, under Mass. Rule 20, which governs permissive joinder. Defendant Reed failed to do, and that alone warrants denial of this motion. 2. Joinder will cause delay and prejudice without...
Hold on, pause for a second here. 1 second. First of all, the procedure of this is very weird. Does everyone understand what's going on? Okay, let's take a poll. I need to know whether I need to actually explain this to you all or whether you're following. Do you understand what is going on in this new overnight filing in the Reed and O'Keefe civil case? Yes, I'm following. No, what the hell happened? Okay. So if a lot of you say you just have no idea as to what's going on, no, I'd like to correct that to overnight. If a lot of you say you have no idea as to what's going on, I will pause a second and try to explain. Okay, I'm not promising anything, but that's what I'll do. All right, so there's your poll. If you understand what's going on, just let me know. If you don't, likewise, tell me you don't. Don't worry about it, Nunya. But yeah, that's a different question, Nunya. We can absolutely come back to it at a later time because it was brought up in the motion. It is substantive. It's not off topic. These potential counter defendants or whatnot, the current defendants in the Bristol case absolutely did mention removal. So we'll talk about that. Okay, so, all right, it's very split. So some of you follow what's going on. A lot of you, half of you follow it, half of you don't. Okay? I think enough of you don't follow it where I'll explain it. My pleasure, Shannon. I'm happy to explain it. All right, here's what's going on. I'm following, but I'd like to talk about it. There you go, Christina. Let's do it. All right, so here's what's going on. The procedure here is very tormented. All right? So a few prefaces. Again, I'm not a lawyer. This is not legal advice. No, I don't know if too many people are even going to understand what this means because this is a very odd situation, okay, procedurally. Now, where's my book? All right, let me get my book. Hold on. Do you want to know what civil procedure looks like. Okay? Here is the book. This book is one of the hardest things you will do if you go to law school. This book is, oh my dear God, it is 1,262 pages, okay? And if you're wondering, Grant, did you buy that book new? Yes, my mom is very kind. I want to show you what it's like when Towel is going to law school. Okay, I want to show you what it's like when I read a case. What was I reading here? I was reading Mr. Herpes' failure to prepare as a Rule 30b-6 designee. Okay, all right. Now, this is what it's like. Okay, you take the book. All right, which page? There we go. No, let's show this page. All right, you take the book. Then you have to underline all this stuff. You see all those notes? Oh, that's going to be hard to see. Hold on. You see all those notes? It's because of my background. But you see all the notes? You have to then underline all of it. You just got to keep reading and reading. So I will tell you right now. And then you have to have a compendium. Do you see this thing? Do you see this thing? Do you see the amount of sticky notes I have in this damn thing? I can't even begin to tell you. Look at what it's like to try to map out civil procedure, bro, on like fucking sticky notes, all right? This was by far and away the most tormenting experience of my life. And I don't want any of you to misunderstand. I am not a lawyer. I'm in law school, okay? None of this is legal advice. I hate when people go around, especially people who have no idea what they're talking about, and are like, oh yeah, like I can weigh in on that. No, you can't. No, you cannot. I want you to understand it, but unless you are actually going to do that, and mostly that's just the baseline, you got to practice to actually know what you're doing. It frustrates me to no end, and this is going to expose a lot of people who comment on these cases, because most people are not going to know what to even say about these civil doctrines, because again, it is civil procedure, which is very different than the criminal justice system. So anyway, that was enough voting. I think we have enough votes. The vote is 62% asking what the hell happened. So let's do it. Here's what's going on. So the timeline is a little tormented. All right. It's true, bossy Texas chick. Well, don't worry, LS. I'm happy to catch you up. All right. So here, if you're just getting caught up, let's talk about it. All right. Let's get composed. The timeline here is extremely tormented. Let's bring it back to that. What we have to think about, first of all, this is just wild to read, okay? Because look, this is the operative part, okay? I know this is going to be really weird, but it doesn't work the way that you think it does. Oh, God, how am I going to explain this? Okay. So, in a criminal case, when someone like say the state, or say the defense files a motion to dismiss, that just goes up on the docket. Okay, it just goes up, and then the prosecution has their time to respond, and then they put their response. Maybe there's like a supplement, maybe there's a reply, but they just go up as things go up. Okay, the civil this is what I'm going to explain, Nancy. So this is why this is a very unique situation. The civil process is different, and I'm not a lawyer. This is not legal advice. I'm not going to do a very good job at this. Okay, I want to preface this by saying that. The civil process, motion practice in civil process is very different, okay? It's different for a number of reasons. One, when you file a civil motion, there are different rules that apply depending on what kind of motion it is. For our purposes, we know from this filing that the package was governed by Rule 9A, okay? They said it in the beginning. That means, okay, that, now they talk about other rules, Rule 21, Rule 15, Rule 20. We're not going to talk about joinder yet, okay? We're just going to talk about specifically Rule 9A. What this means is that in a civil case, when you file a motion, you don't go to the docket and submit a motion under Rule 9A. You go to the other party, okay, and you say, here's my motion. Then the other party has like a certain number of days, whatever it is, and you two talk about how long it needs to be. There's a set number of days, but each party kind of negotiates that. Then the other party sends you back their response. They don't docket it. they send it back to you. Procedurally, they send it to you, okay? Now, you take your filing and their filing, and then you decide if you want to do a reply to their filing. If you don't want to do that, then you have the obligation as the movant, the person who moved the initial motion. This is not legal advice, I'm just telling you the rules. It was mentioned in the motion. You take everything that you have, okay? You take your motion, whatever you attach to it. You take their reply, and he attaches whatever they attached. Then you take your reply, if you did one, to their reply, and you put that in there. Then you make a cover sheet, and you're like, okay, here's what I'm submitting, Your Honor. And you go to the clerk, and you give them your initial document, the person's reply, your reply, if applicable, and anything else relevant to the 9A package, okay, service, whatever. You then docket it all yourself. Then that hits the public docket. What we have, so if everyone's on the same page about the 9A process, hell yeah, Bossy Texas Chick. We love the 9A process. What this means, and this is why this is so, I'm glad we actually paused, because this is actually incredibly convoluted if you don't understand what this document is. This is not a moving paper from the Canton aristocracy as a new motion. This is their reply, okay? There is out there, somewhere in the ether, not on the docket, a motion from Karen Reed to add these people as counter or cross defendants, whatever it's called, when you bring someone in to an action. It's actually snowing. It was snowing this morning for a little bit when I was walking around. I'm going to let it catch up, though. Oh, it's back. All right. So getting back to this point, okay, this is complicated because what this means is out there in the ether, there is a document from Karen Reed that these defendants are responding to, okay? So because they are responding to a motion she filed, but we don't actually have that motion, this is weird to read. It's weird to read because you don't know what the original motion was, and Karen hasn't filed these on the docket. This just got released at midnight, all right? Now, something else that's so fascinating about this, okay? And we're not even 1/3 through this. Something that's so fascinating. I commented about it on Twitter already. My mind is just wild with thoughts right now. Okay. In the beginning of this motion, which they must have been working on since October 28th, in the beginning of this motion, the defendants in the Bristol case start off by saying, where is it? Right here. Hold on. It's not this part that we want. We want the part where they say Karen just filed a new pleading. Where is it? She just said it. They just said it, didn't they? Oh, having been served. Oh. Wait a minute. I thought this part was saying having been served in the other case, okay? But so they were only served, according to their response here, with the motion and then the proposed cross claims, okay? Now, let's see if they mention at all the Bristol County case. No. Oh, this makes them look so bad. Whoa. When was this filed? Hold on, we'll get a date. One sec, I gotta go to the end. Hold on. November 12th. She sandbagged him. Oh, wow. So do you see what happened? She filed this thing, a motion initially in late October, and in it she was doing a cross complaint. But simultaneous, right as this reply came in, we need to check the exact date for when Karen's civil complaint went up in Bristol. Right as that's all going down, she files a standalone action. And then here you have the Canton defendants saying, under their last part of the argument, Reed's motion to bring them in to the Plymouth case should be denied And Karen instead should file her own pleading in a separate action, which Karen did. So this makes them, I know we're reading something from 10 days ago now that I looked at the date. It didn't come out till overnight. This makes them, like, she totally got ahead of them and sandbagged them, because they're saying, oh, she should file a separate action, and if the separate action survives dismissal under 12b-6, then it would be appropriate to consolidate. Bro, she did file a separate action, so now your response to her motion to consolidate is mooted. This is a lot. Do you see how it's a lot of chess playing? You know what I'm saying? It's why civil practice, just from a lay perspective, is so fascinating. Okay, it's so interesting. Because you got stuff like this. Like, you have to think about that. Like, I'm just commentating here. These defendants should have known that she was going to sue them in a collateral or separate action, and then, like, they should have seen that coming. It happened instantaneous to their, like, this going on. They should have realized that what she was going to do is she wasn't making the motion for cross claims as the be-all end-all. It was so that motion could be on the docket, and then they would respond, and then she could undermine their response procedurally by being like, I did file a separate action, their response is moot, you should join these cases. In fact, they argue for her. My mind is blown right now. This is some good lawyering by whoever was working with Karen. Wow. That's so interesting. You see what she did, though? Karen set it up so that now when they go argue these motions eventually, Karen's lawyers are going to be like, Your Honor, they said it themselves. If that other action survives dismissal, it may be appropriate for the parties to consolidate the cases. Based on this? Oh, it's so hard to analyze that right now. I can't answer that question, LS. I haven't seen enough. First of all, I want folks to know how different tactical posturing is in civil cases and criminal cases. Second of all, Karen must have, it must be more than just Alan. It must be the other guy too. I didn't even know Alan was a civil litigator, like who was an expert in that. This is a very smart move. I mean, whether it's like playing fair, I don't really know. I don't know enough about it to comment. But it's really smart that she, in essence, got them to argue for her point. You see what I'm saying? Because she, after they're like, well, she should just file a separate action, she did that instant. She was already going to do that. You don't do that overnight. She did it simultaneous to this. And then I think what she'll do is either amend, I'm just guessing, I'm not a lawyer. I think she'll amend the motion for joinder in light of the new filing. And then it will be permissive joinder under, or it will be joinder under 42 or whatever that specific joinder rule is. That's brilliant litigation strategy. I mean, they probably didn't see it coming, the lawyers for these defendants. I'm a lay towel, not a lawyer, okay? I'm not giving legal advice, I'm analyzing. They're in a tough position because their whole argument hinges on that paragraph right there. And then the other thing, I don't know what they're doing here, because these defendants in the Bristol case are not in control of their own destiny in the Plymouth case, and I'll tell you why. So, one, if you go to right here, first of all, this affidavit, okay, is based on testimony from Natalie and Lindsey. Okay? So, like, the gall of these witnesses who had Kate Peter, I don't know if they had her or Kate Peter was out there, whatever. Kate Peter is the one who, with Michael Gaffney, sabotaged Lindsey's fundraiser. So the fact that these witnesses are relying on the information that Lindsey gave to Tully, before Tully leaked her phone extraction, by the way, completely unredacted except for messages from Kate to Lindsey and from Tully to Lindsey removed, and also an audio of Leah Genduso removed that apparently had to do with Leah ninja kidnapping Aiden and hitting him in the head. When I read that, I was like, wait a minute. What? Why did you want to ninja kidnap him? Don't do that. Like, there's just a limit, you know? Like, you don't have to ninja kidnap him, even if you really don't like someone. We really don't need to be ninja kidnapping people. I'm a little baffled how we even got ninja kidnapping involved in all of this. I think it's kind of ridiculous, but at the same time, if your brain has at any point in time been like, I think it's a good idea to ninja kidnap someone, whether or not you're going to hit them in the head with a weapon or not, let's set that part aside, because that's also wrong. Just stop right there. Like, if you're sitting in a bathtub somewhere and your brain's like, I think I should ninja kidnap someone. Okay, pause, stop. Like, that's the circuit breaker. Like, no, brain, stop thinking that. And then also, no, you should not do that. Why would you do that? One, you're not a ninja. Just as a basic premise, like, unless you somehow were trained in Japan as a ninja, you're not a ninja. Second of all, and more importantly, you shouldn't kidnap people. Regardless of the point of the kidnapping, regardless as to whether you're even a ninja, you should not be doing that. All right, are we all on the same page? Excellent, Nanya. All right, everybody taking notes? No ninja kidnapping people. If you take anything away from this stream, I know the rules of civil procedure are very important. You may not ninja kidnap people, all right? Everybody, whether you're in a bathtub or not, we're going to do lines on the chalkboard. Not those kind of lines, literally writing on the chalkboard, I will not ninja kidnap people. All right, there we go. Anyway, my point is, this argument isn't very good either, in my opinion, on the lay towel, but look at this ridiculousness. If you read the O'Keefe's pleading, okay, which I have, the original complaint, not in like motion practice, just the original complaint, the four corners of the complaint and its affidavits and accompanying exhibits. Folks, you can read verbatim in that complaint a reference to Brian Tully's affidavit about Lindsey that had information from Lindsey and from Natalie. We'll talk about both of them individually and how that's relevant in a second. Okay? It makes reference specifically to paragraph 79 through 82, by the way, which has to do with Lindsey telling Tully about how Karen controlled what Aiden would publish. But the point is, the O'Keefe family brought that up because it plays into one element of their complaint, which I think is the IEED. I don't remember exactly which part of it was in. But folks, do you understand like why that imperils the Canton defendants here? Because I knew it at that moment. Immediately when I read the O'Keefe complaint, which was good. It wasn't bad. It was good. But immediately when I read it, okay, I was like, wait a minute. Wait. What are you opening the door to right here by talking about that affidavit? One, it shows that Lindsey was very important to all of this, okay? Because not only, you got to understand the timeline. Karen and Aiden start talking in like April of 2023 through Jen Altman, okay? And when Karen and Aiden start talking, Aiden's got something else going on with Natalie Haskin or whatever, Victoria Haskin or whatever her name is. That story's wild. But Aiden's got something else going on. He's not really concerned with Karen Reed, okay? They have a friendship of convenience that for the first few months is mediated with the feds involved in all this, by the way. That part blows my mind, but I think the feds probably they know more than me now, they knew more than me then, and I think they were on the right track, just using weird tactics. I don't want to talk about that right now. The point is, Karen and Aiden were using Natalie as an intermediary. I'll call her a pseudo-intermediary, because really there were multiple intermediaries, but let's just use Natalie, because she's the one who's cited by Tully in the first part of the affidavit. Aiden is communicating with Karen through Natalie, okay? Natalie and Karen, listen, I finally figured out what happened, by the way, because I listened to Natalie's interview with Tully that someone had posted. I think Aiden posted it initially like a year ago or something, and then someone else reposted it recently, so I watched it like last month. They didn't have a falling out over houseplants, bro. I thought they fought over houseplants. I don't know who told me that. Nonsense. Nonsense. The reason that Karen and Aiden had to fall, Karen and, what's her name? Natalie, Wiewicki Bernicki. People call her Natalie the German, but it's like Natalie. Let's just use Natalie. They had a falling out because Natalie is like some high connected, like Hollywood PR type, okay? Like, she knew somebody at Sony, and she connected Aiden with them, but was like, Aiden, bro, like, don't rush into anything about this, okay? And Aiden wanted to work with Sony and just did it. And that Karen didn't like that. And that's why Natalie and Karen stopped talking. Because Natalie was like trying to help, I guess. I don't really know. I haven't talked to her. I don't know her motives. I think she was just trying to help Karen. And by trying to help Karen, she involved Aiden through Jen Altman. And then Aiden was like a wild card who they didn't really understand. And when Aiden just started doing his Aiden thing in a non-diplomatic way, Karen held Natalie accountable for it. But Karen needed Aiden, okay? So she punished Natalie, in my opinion, for screwing up, like, handling Aiden. Like, if you're going to do that, bro, like, you don't give him the Sony connection. You're like, okay, Aiden, we're going to work on something, and you role play him. You compartmentalize him. Natalie didn't. She gave him the whole ball game. He used it against her, okay? And she was not very smart. In turn, Karen kept working with Aiden. And she didn't have an intermediary. She just talked to him directly. As a result, Aiden, through his indiscretions and pillow talk, was telling Lindsey about what Karen and Aiden were talking about. And Aiden was putting it into writing, which is bad OPSEC, operational security. Eventually, Karen cut ties because she realized he was a liability and there was nothing she was going to be able to do other than keep him under control. But the point remained, and then obviously they kind of ebbed and flowed, and then the recording thing happened. The point remains the same, okay? The O'Keefe family referenced and relied on not only Natalie's intermediary communications with Aiden and Karen to establish an element of their underlying original complaint in Plymouth, but they also reference paragraph 79 through 82, which specifically has to do with Lindsey and Aiden and Karen, okay? So for the fact that these witnesses, okay, I see it 100% now. They were running, in my opinion, state resources to do their own investigations, to gather all this intel for whatever purpose they were going to use it for, criminal, civil, or otherwise, all right? And I think there's something to that, okay? I think there's something to why they were doing that. I don't really know. I'm starting to see the full picture, but it's just ridiculous to me, because to pull it back to the argument, I wanted to say hello to Young Black Economist and Alicia. But yes, hello to both of you. And I also want to circle back to one more thing, okay? What the defendants are arguing here, let's understand what they're doing, the Canton defendants. They're saying, no, you don't understand, Judge. Like, Karen's just, like, bringing up us because, although there's some connection to John O'Keefe's death, she's really just bringing us up based on this, like, completely unrelated series of events that has nothing to do with why the O'Keefes filed their complaint in Plymouth. That's just not right, okay? It's wrong about their original complaint, and it's not like they referenced it in passing. The O'Keefe's original complaint specifically talks about, as an element of one of their claims, if not multiple of their IEED claims, the continuing pattern of events involving Karen and Aiden. As I mentioned, it references Tully's affidavit. Now, setting aside how chaotic this is going to be, because Tully has his own conflicts of interest. He doesn't, I don't think, as much with certain members of the O'Keefe family. He does with Jen McCabe and Kate Peter. It opens this whole can of worms, because it means that those affidavits, those search warrants, they were serving a dual purpose. They were serving a law enforcement purpose to get the search warrant of Karen's phone for a potential pending indictment of Karen and Aiden on new WI charges and conspiracy to commit those charges. But at the same time, they were being used to gather evidence, which was clearly then used in the civil proceedings by the O'Keefes and... All right, so these defendants aren't even relying on it. But the fact that it was used by the O'Keefes, you have to understand the context of that. It was made in furtherance of a part of their claim. It is thus central to the complaint, because the complaint isn't wrongful death. Oh, Jesus Christ. That's why this is so bad. The complaint is not wrongful death. That is one element of the 13-count complaint. I think 3 counts were dismissed, so there's 10 remaining. That is one element, one segmented portion of the complaint from which other things stem, but it's also IED, intentional infliction of emotional distress, negligent infliction of emotional distress, and part of one of those claims, if not multiple of those claims that survived the motion to dismiss, was specifically Aiden and Karen talking in the evidence provided by Tully. So no, this is just wrong. It's not just wrong, it undermines, first of all, this motion. They can say Karen's motion is procedurally deficient, or there's some convoluted different joinder rule she should have used, and then the procedure may have played into that with the other lawsuit being filed. That's not a very good argument anyway, so I'm throwing that out. This one is even worse, because it's not like Karen just came in and said, hey, here's some unrelated thing I want to bring up. No. Her entire cross-complaint, if you read the lawsuit filed in Bristol, which is definitely just a mirror of the original attempt at a cross-complaint, although I think that original cross-complaint was tactical, as I mentioned, to make these defendants look dumb, because now they're arguing that all she has to do is file a new lawsuit, which she's already done, and then move for joinder, which she's going to do. And then they're also saying, they're trying to undercut Karen's argument again by saying, well, they're not the same operative facts. If the O'Keeffes had only mentioned the events of January 28th, January 29th, and maybe a little bit before, a little bit after, like any time before April 2023, if they had stopped, okay, you have a valid argument. This is not a valid argument, okay? The O'Keeffes themselves talked about that, whether for better or for worse. We're not even going to analyze the merits of whether or not it strengthens or weakens their various civil claims against Karen. They opened the door by arguing it. Therefore, of course, Karen's entitled to joinder. Because they create that window, you can go through it. Once you're through it, that's it. Because of that causal chain, I'm not a lawyer, this is not legal advice, because of that causal chain concept we talked about earlier. You just need a window, an opening, and Karen has it. This is a bad argument. When they made this argument, I know we're a few pages past it, I was like, what are you saying? What are you saying? Like, you're making a terrible, terrible argument here, because what they're mirroring exactly the language used in the O'Keeffe's initial complaint, like verbatim almost. They're not citing to the exhibit like the O'Keeffe's did by paragraph, the Tully's affidavit for the search of Karen's phone in January 2024. No, but they're quoting the argument verbatim, which shows that they have an understanding that the O'Keeffe's made this argument. And then they go on to say, oh yeah, and by the way, it's just completely unrelated to the O'Keeffe's claim. No, it's not. Yes, young black economist, it is great to see you. Let's continue with reading the document, though. And I realize I did a little pause there because not many people are going to understand the procedural nuance that got us here. The procedural posture is what it's called. So I think I've pretty much brought us all up to date on why the procedural posture is so interesting. But then we got to do the whole next part, which is we got to finish reading the document, and then also we have to do what's called an IRAC. All right, we got to go through each issue that's brought up. Then we got to do look at the rule they're citing to, determine if they're right, then do an application of the existing rule to their facts. Then we got to come to a conclusion. That's what we're going to do this morning. And if we get to trivia at the end of the document, we do. I really want to. I'll stay with you as long as I can. We're going back to the document, though we have to keep reading.
Any efficiency or judicial economy. Even if this court were to treat defendant Reed's motion as being made under Rule 20, the motion should still be denied. Under Rule 20, this court has the discretion to allow joinder of parties and counterclaims, but should only do so where it would promote trial convenience, and not where it would result in prejudice, expense, or delay. Whittier IPA, Inc. v. Steward Healthcare Network, Inc., 1484 CV 03029 BLS2, 2017 WL1449763, at *8, the 19th of January, 2017. Quoting Alman v. Chugach Support Serves. Inc., 485 F3D 206, 218, 40H Sir 2007. Here the court should decline to exercise such discretion. Defendant Reed's proposal to join the Commonwealth witnesses and other third parties to this wrongful death action would not advance judicial economy at this stage but, rather, would substantially increase the complexity of the pre-trial proceedings and result in delay and prejudice to the Commonwealth witnesses and the plaintiffs. There are several reasons for this court not to exercise its discretion to join the Commonwealth witnesses to the existing wrongful death action. Defendant Reed's proposed course of action will prejudice the Commonwealth witnesses' discovery and jurisdiction rights and will substantially complicate and delay the pending wrongful death action with new parties, claims, factual disputes and legal issues, without any genuine judicial efficiency gains. But the Commonwealth witnesses will have substantial motions to dismiss if Defendant Reed is allowed to file her proposed cross-claims in this action. If Defendant Reed is permitted to file the proposed cross-claims against the Commonwealth witnesses in this wrongful death action or if she files it in a separate action, those pleadings will be subject to substantial motion practice. Anticipated motions to dismiss include requests for dismissal based on the Massachusetts Strategic Litigation Against Public Participation Act, Mass. General L. Chapter 231, 59H, the Anti-SLAPP statute, as well as on statute of limitation grounds. Such motions are likely to be successful or, at the very least, substantially narrow the scope of Defendant Reed's proposed cross-claims. 1-1 in Bristol Asphalt Company, Inc. v. Rochester Biomin Musprod. Inc., 493 Mass. 539, 555-557, 2024. The Supreme Judicial Court recently established a two-part test for consideration of an anti-SLAPP motion. If the moving party establishes that the challenged conduct is based solely on the moving party's petitioning activity, then the burden shifts to the non-moving party too. Moreover, under the anti-SLAPP statute, all discovery in this proceeding would be automatically stayed once the Commonwealth witnesses file that special motion to dismiss. Mass. General L. Chapter 231, 59H. While the court could resume discovery for some existing claims in the wrongful death action, there is a serious risk of multitude discovery if Defendant Reed's proposed cross-claims are brought into this case at this time. These timing issues are compounded because the Commonwealth witnesses would have the right to an immediate appeal if that anti-SLAPP motion were denied. Fabre v. Walton, 441 Mass. 9/11, 2004. Given these significant legal deficiencies in Defendant Reed's proposed cross-claims, this motions practice could take the parties several months if not longer to brief and for the court to resolve these motions. Further, if some of Defendant Reed's proposed cross-claims were to survive dismissal, the Commonwealth witnesses could be compelled to file their defamation action as counterclaims against Defendant Reed and Mr. Kearney in the present action. That could result in further motion practice. In the meantime, discovery in the present wrongful death action could be substantially complete. Indeed, the current discovery schedule ends in August 2026, which may leave only a few months for discovery on Defendant Reed's cross-claims and the Commonwealth witnesses. Defamation counterclaims. That truncated discovery would needlessly and substantially prejudice the Commonwealth witnesses, which alone also warrants denial of this motion and are established by a preponderance of the evidence that the petitioning activity was devoid of any reasonable factual support or any arguable basis in law. ID here. Defendant Reed's claims against the Commonwealth witnesses are based unquestionably on core petitioning activity speaking to the police. Defendant Reed cannot show those activities were devoid of any reasonable factual support. Indeed, Defendant Reed complains that the Commonwealth witnesses told the police that Officer O'Keefe did not enter the home at 34 Fairview Road. But, that is exactly what Defendant Reed told the police in January 2022. Direction that Defendant Reed pursue a separate action. See Whittier IPA, 2017 WL1449763 @ exercising discretion to deny joinder when it would not provide the new party sufficient time for discovery and relatedly delay the pending proceeding. Alternatively, discovery in the wrongful death action may be stayed pending these motions, which would also needlessly delay adjudication of this lawsuit. 2b. Defendant Reed's joinder strategy will prejudice the Commonwealth witnesses by likely foreclosing their right to remove the litigation to federal court. Next, Defendant Reed's proposed cross-claims include several counts arising out of federal law, including Count 4 for conspiracy to deprive Miss Reed of her Fourth Amendment rights against the McCabe's, the Alberts, and Mr. Higgins. Absurd as it is on the merits, if Defendant Reed files this pleading in a separate action, the defendants would have the statutory right to remove Defendant Reed's complaint to federal court under 28 U.S.C. 1441, c. However, by adding these claims as proposed cross-claims in the plaintiff's wrongful death action against the proposed counterclaim defendants, Defendant Reed will likely foreclose Commonwealth witnesses' right to seek removal to federal court. In particular, the Supreme Court has held that removal under 28 U.S.C. 1441, is not permitted for counterclaim defendants. See Home Depot USA, Inc. v. Jackson, 139 S.CT 1743, 1748, 2019. Counterclaim defendant cannot seek removal to federal court under 28 U.S.C. 1441, a. Since then, courts have expanded the Supreme Court's reasoning to include 28 U.S.C. 1441, c, which covers removal for federal question jurisdiction. See Bowling v. U.S. Bank Natal Association, 963 F.3d 1030, 1040, 11th Sir 2020. 2. To the extent there are any efficiencies that can be achieved in discovery, that can be accomplished in separate proceedings under Mass. R. Civilian. P. 42. Given Defendant Reed's tenure spaces to seek leave to join claims relating to her criminal prosecution to this wrongful death action, the court should avoid inflicting undue and unfair prejudice upon the proposed new cross-claim defendants. By denying the motion, and forcing Defendant Reed to file this pleading as a new action, the court will ensure that the proposed counterclaim defendants' jurisdictional rights are not inappropriately foreclosed. See if the motion is allowed, the Commonwealth witnesses will have to file defamation and other related counterclaims against Defendant Reed and third-party Aidan Kearney in this wrongful death action. Finally, Defendant Reed's motion would not only expand the present wrongful death action with her proposed cross-claims and the additional parties related to her criminal prosecution, but the Commonwealth witnesses would also be forced to file counterclaims against Defendant Reed for defamation and other torts in this action. The Commonwealth witnesses also would have to join third-party Mr. Kearney to this action to assert similar counterclaims for defamation and related torts. As explained above, Defendant Reed and Mr. Kearney, both in concert and separately, have defamed and substantially injured the Commonwealth witnesses through myriad false statements about them for which the Commonwealth witnesses have planned to seek justice in a separate action. While the Commonwealth witnesses contend their defamation claims and other torts against Defendant Reed and Mr. Kearney should proceed in a separate lawsuit, if Defendant Reed is permitted to bring her proposed claims in this action, the Commonwealth witnesses may be compelled similarly to bring their defamation claims in this lawsuit as well. These additional claims and parties related to unlawful conduct by Defendant Reed and Mr. Kearney after the death of Officer O'Keefe would further complicate this wrongful death action, by increasing the number of parties, claims, factual disputes, and legal questions. As a result, Defendant Reed's motion would not create any judicial efficiencies at this stage by having these disparate legal claims, based on different facts and time periods, against different parties in a single lawsuit. 3. Rule 42 consolidation may be appropriate between the separate lawsuits at a later time. Defendant Reed provides no genuine justification for adding the proposed cross-claims and the 10 new cross-claim defendants to the pending wrongful death action. As stated earlier, Defendant Reed's proposal will substantially expand the scope of the pending lawsuit, including dramatically increasing the number of claims, parties, issues of factual dispute and legal questions for resolution. It also risks unduly prejudicing the Commonwealth witnesses by truncating discovery on their claims and artificially foreclosing jurisdictional issues. However, it is possible that if Defendant Reed pursues her proposed cross-claims in a separate action, as she should be required to do, the parties and the court may determine, after motion practice is complete, that there may be some efficiencies from consolidating discovery or the claims for trial under Mass. R. Civilian. P. 42. Until motion practice is complete, the parties will not know the potential for judicial economy from consolidation. At that time, the parties and the court will be able to assess the remaining claims and parties, including the defamation claims against defendant Reed and Mr. Kearney, and be better situated to determine whether consolidation is warranted. Conclusion: for the foregoing reasons, the Commonwealth witnesses respectfully request that the court deny defendant Reed's motion pursuant to Rule 21 to file the proposed cross-claims in the pending wrongful death action. Respectfully submitted, dated, the 12th of November, 2025. Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins, by their attorney, /s/James L. Tuxbury, BBO #600.
All right, so who's ready to learn about what just happened? Okay, so couple important points. One, and this is kind of interesting for a number of reasons. Let me explain what's going on here. So we got to draw a little timeline. How do I do this? I wonder if I can like open up something and draw a timeline for you. It's going to look really weird. I wonder if I can I wish I had like a whiteboard. All right, here's the best way to understand it. Go back to October 28th, 2025. All right, this is the best way to understand the procedural posture of this before. Oh, no, I'm not buffering. I think it's just the internet bossy Texas chick. Don't worry. But let me just explain the procedural posture of this, and then we'll see if we can play some trivia, okay? The procedural posture is, go back to October 28th, 2025. This, first of all, someone was asking, I think FBI, DOJ, this motion hasn't been denied. She hasn't lost it. It wasn't even filed, because you have to submit the motion to your opposition, to the parties you are like involved with. They have to submit oppositions. Then you have to submit your reply if you want. Then you have to package it all up and give it to the court. You don't just like docket something in civil cases. There's been no hearing on this. There's been no ruling. We're just reading this during the middle of the 9A filing package. It is not upside down. No, Donovan, it is right side up. So maybe you're upside down. I don't know, but I'm right side up. But let me talk about the timeline. So October 28, 2025. The O'Keefe's lawsuit is already open against Karen, obviously, and moving forward. Karen initially files a motion on their docket as a counterclaim against Jen McCabe, Brian Albert, Matt McCabe, Nicole Albert, Brian Higgins, Michael Proctor, Yuri Buchanan, Brian Tully, the state police, and the town of Canton. But, so she files that on October 28, 2025. She sends it over to these people, to everyone she just named, plus the O'Keefes and anyone else involved in the Plymouth case, okay? They get that document, and then that kicks off a process where they have to start working on their response, okay? It's a motion. They all do that. While that's pending, and this is what makes it so brilliant, it looks like Karen really set him up, because this was due on the 12th of November. What day did Karen file her lawsuit, by the way? Can anyone get me the exact day that Karen filed that lawsuit? It was the 13th at 3:53 p.m., wasn't it? And then the world knew it on the 14th. She made them write this, okay? She knew what they were going to write. Her lawyers definitely were telling her. I loved the Fred Flintstone comment, bossy Texas chick. Listen, Karen's lawyers, in my opinion, definitely knew. They were telling her to do this, in my opinion. I'm not a lawyer, I'm a towel. And this is not legal advice. But I think what Karen's lawyers did was like, listen, do this as a cross-complaint and let them respond to that, because they're going to say in the response, hey, she should really file her own pleading. Then once they do that, file your own pleading simultaneous to their response, because again, no one sees this. It's not on the docket. It's just between the parties. The judge doesn't even get it until the 9A package is filed. File the new lawsuit as they submit their response to your motion for joinder and counterclaims, or motion for counterclaims, or whatever it is. And then they're going to argue in that motion, you should file a new lawsuit. You'll have already done it. And then when we go to oral arguments on this, I'm not a lawyer, this is not legal advice, you can say to the judge, hey, we already filed a separate lawsuit. They're the ones who are saying now it's time for a Rule 42 motion. Why don't we just do that? See, Nunya thinks you're hilarious, Bossy Texas Chick. But let me just say, that's why this is so fascinating. This was very interesting strategy. And I don't know if a lot of people are going to see it, but I'm glad to be able to explain it to you. The strategy here is just fascinating. To have them file this and then immediately bang them with what they tell her to do, because Karen didn't file her new lawsuit overnight. She waited to file that new lawsuit until they submitted this document so that when she goes to oral arguments on this, her lawyers can say, we already filed that new lawsuit in Bristol, Your Honor, and we intended to join it. We just didn't have it ready. Oh, the wonder of it all. I shouldn't laugh, but it really is this is a chess match, okay? This is not a regular case. This is a chess match and a half. This is like multi-district litigation. It's not multi-district litigation, but it's as complex. And then throw in that other fascinating thing about how if you counterclaim, you can't move to remove the person you're counterclaiming, can't move to remove the case to federal court. And these are all governmental defendants who I'm sure would love to be in federal court. Not that Karen couldn't go up there and fight in federal court. All right. So, let's think about this. They didn't know, these defendants, they're cross defendants and defendants in the Bristol case. They didn't know she was going to file that. They wrote this motion. That's why it's so weird to read. That's why some of you are probably baffled. It's not, whether or not, irrespective of whether counterclaims are appropriate here or a standalone lawsuit, that's a matter for the fact finder, for the judge. That's not a matter for us. What's a matter for us is the timing, the analysis of the timing. Because what it basically is it's sandbagging them. This response is moot. Okay, it only has two aspects of it. A few aspects. There's only three arguments. Their first is they're going to do an anti-slap motion, okay, and that might stay discovery, and therefore it's not really efficient. But the substantive arguments are that the thing about removing the federal court, they argue they're prejudiced because cross-claiming doesn't let them do that. Well, okay, everyone would then thus be prejudiced. And then they're also talking about just a lot of the delays, okay? But fundamentally, their argument up at the top, okay, their main arguments are that this wasn't appropriate because there was no standalone lawsuit, so therefore a cross-claim wasn't appropriate here and the rule invoked was not appropriate. Their other argument is that, the more substantive one, is that Karen's cross-complaint was outside the scope of the O'Keefe's original complaint, so it was not related to the nexus of the original complaint. I don't believe that's right either. That's going to get thrown out. It's a very weak argument because, as mentioned, the O'Keefe's rely not heavily, but at least in a paragraph, directly on, not just on the Tully's affidavit, but they use it to substantiate part of one of their NEID or IEED claims, negligent infliction of emotional distress or intentional infliction of emotional distress. All right. Though that's pretty weak, but interesting posturing. Very interesting, because here Karen has them arguing for her. It's possible that if Reed pursues her proposed cross-claims in a separate action, as she should be required to do, the parties in the court may determine after motion practice is complete that there may be some efficiencies from consolidating discovery of the claims for trial, or consolidating them for trial, but they don't spell it out here. So I'm just saying, she got them to argue for her. It's not even sandbagging, it's just it's sandbagging in the sense that they should have known this was coming, but they're basically saying yeah, Your Honor, maybe if she hadn't filed in another case, they're saying, Your Honor, if she had filed another case, okay, then we can talk about permissive joinder or Rule 42 joinder or whatever that is. Okay, well, she did that, so this is moot. That's why I think the timing, it can't be a mistake. It's all... Nothing is coincidental. I keep trying to tell people, just because some things happen in the moment and you don't have the benefit of hindsight, or we don't, that doesn't mean there's not a tactical purpose that we don't understand, that we're not being told about. This is what's going on. Listen, this case is going to become massive. All right? It's going to just sprawl. If, like, all these defendants and the O'Keefe family, and then Aiden and Karen, bro, this is going to be, like, ridiculous. Unlike anything we've ever seen before. Like, and we need to get ready. It's going to be years, by the way. It's going to be years. But we need all to prepare, because the intricacies of the civil process are going to dictate a lot of the ebb and flow of the lead up to the trial. This is going to be ridiculous. How many parties are we at? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. 18 parties, if all of this plays out this way. At least. I think it's 18 parties. Whoa. What? What? These people are going to be in each other's lives forever. Bro, this is going to go on forever. And the reason we're just seeing it now is because the 9A package isn't even filed. So anyone saying like, oh, Karen lost, whatever. No, she didn't lose. She chose tactically to foreclose the Canton defendants' arguments in this motion by filing a separate complaint the day after they filed their response to her motion. That was not an accident. She did that because she knew they were going to argue this. Yeah, it is very rare where you see a civil case that is like a criminal case. Maybe the OJ civil case is a good example. I was very young for that. But like, even that, I remember it being very protracted, and it wasn't really as much of a focus of attention as the criminal case. This is going to, and what's really weird is, there will be a new Norfolk DA. I'm telling you right now, we are within 12 months of the election for the new Norfolk DA. Michael Morrissey, according to not only my sources, but a number of people now on social media saying it, is not running again. Okay, so that means the person in charge of, like, some of this stuff, because at least some of these people were working for the Norfolk DA, like the records, all this stuff. It's like when President Trump came into office and all this stuff started coming out about Crossfire Hurricane and how Carter Page was in the CIA and Lisa Page and what is the other guy? Peter Strzok misled the FISA court into thinking Page was not in the CIA, so the FBI under Obama could get a warrant to spy on President Trump because Strzok and Page tried to make it look like Carter Page was talking to the Russians when really Carter Page was a CIA asset talking to the Russians because he needed to talk to the damn Russians. See what I'm saying? So anyway, it's kind of like it's kind of convoluted in that regard, but it also is very explosive because if the new Norfolk DA comes in and has access to all these records and then is able to expose what happened, that then makes this case even more explosive because there's no institutional protection. This is like the wildest of all possible outcomes. Like, I knew there was going to be a Norfolk DA race, but I thought it would kind of be like Democratic Party establishment people, or like just more like the existing power structure. Deutsch was a wild card no one could have predicted, right? I mean, I couldn't. No, I don't think anyone could have predicted that. It was a very interesting change, and I think it changes the game. And I think it also, like, again, you're starting to feel out as you read these initial pleadings in the civil case, like, who has the good lawyers, like who knows what they're doing, and you won't always see it immediately. You really need to analyze. If we didn't go look at the date at the bottom of this motion right away, right? If we didn't take the time to see this was filed November 12th, we wouldn't have been able to put together the timing of then Karen's other action being filed in Bristol Superior Court. See what I'm saying? So you really, and then you have to understand the 9A process. You have to get acquainted with some of this stuff because it really is, no pun intended, what lies beneath. It's not just what lies beneath in Canton. It's what lies beneath, like, the unspoken, what's not here. It's like jazz, some of these motions. It's as much about what's not there as what is there. You know what I'm saying? So, But yes, okay, so we read through that, and we will play some trivia. We absolutely will do so, and that will give us the opportunity to get caught up. So I enjoy playing trivia. I think that's kind of fun. Let me see if there's a video that I can play, though, before we play trivia, because I wanted to get caught up on one other thing, and that'll be the teaser for what we're going to do after trivia. So let's watch a video. What videos do I have? There was something I'm going to remember. Hold on. I got so in-depth on that thing, I kind of forgot what was going on. Oh, I know what I wanted to watch. Okay. So watch this very funny video. It's only like 60 seconds. It's about... Hold on. This video is... it has me typing on a towel typewriter, and I think it's really funny. So watch this for 60 seconds. I have to get trivia ready anyway, so...
My job is to be that light, even when the darkness pushes back. It feels like a stitch.
I see it. The courthouse.
All right, so it's not quite Thanksgiving themed, but I liked that. All right, so here's what we do. We're going to play trivia. I got it all ready. I'm excited. Good morning, Bunny. Pete Bunny Towel. Bunny's here. You want to come over as I explain trivia, Pete Bunny Towel? All right, who's played trivia before? Some of you have, some of you haven't. Here's how it works. It's a pretty fun game. We're going to do at least 3 or 4 rounds today. Yesterday, that's what we did. We had a fun day. It was pretty competitive. Allie and Rue are wearing the crown. I don't know if they're here. Sometimes I just say Allie and Rue, and they pop up in the comments. So, now, if you're new to this stream, if you were having a fun time learning about civil procedure, we are going to absolutely play towel trivia. Bunny, it's Pete Bunny Towel. He's very excited to see you. This is Pete Bunny Towel. He is my co-Pete Bunny Towel. Well, he's telling me I'm not actually a Pete Bunny Towel, but you know what? We can get along with it. We can get along today. All right. Anyway, we're going to play trivia. Here's how it works. So in a second, you're going to see a screen come up when I put Pete Bunny Towel down. And that is going to be our trivia game. All right, there's going to be questions. We're going to play rounds. They're categories, so we pick a category, or we normally warm up with the daily challenge. Then we're going to pick categories, and we'll do some holiday-themed ones today. We also watch videos before each category. Each round takes about 10 minutes because we learn a little bit about the category, and then we do a set of questions. Who framed Roger Rabbit was underrated? Well, maybe that'll be a trivia category today, Nunya. So what we're going to do, though, is we're going to play this trivia game, and I'll explain to you the rules. So each round is 6 questions. During the rounds, you are going to see the question go up on the screen. There's going to be 4 answer choices, 1 through 4. You're going to get the question read out by me. I'm then going to wait till the very end of the timer, and then I'm going to answer the question. If I get the question right, I get a point. All right? The first person in chat, according to my phone, and we have to go based on my phone, unfortunately, because that is the only way that we're able to do this. We have to go based on my phone. Gets a point. Any right answers after that, half a point. Wrong answers, no points, no penalty for wrong answers. Now, if we are in a regular round and I get the question wrong, Pete Bunny Towel, stop distracting me. He is very adorable. What do you want me to do? If we're in a regular round and I get the question wrong, however, you get 2 points. All right? 2 points. If you're the first one to answer it. If you are get a right answer after the first person, you get a full point. If we're in a double bonus round, though, which I will announce ahead of time, that has to be a round I know a lot about. No complaining that the double bonus round is a topic I know a lot about. That's the only way that it is a double bonus round. In those rounds, if I get the question right, regular scoring rules apply. 1 point if you get it right, half point if you get it. What was a novel invention of war during the siege of Constantinople in 1456 by the Ottomans? And Bunny was the only one who knew it was the cannon, because Bunny had learned that if you get it right after the first person in a double bonus round, with me having gotten it wrong, you get 2 points. It's a great way to pick up points. It's a great way for the scoreboard to jump around. Pete Bunny Towel says he hates the damn commies and he wants me to get started with trivia. All right, let's do it. We're playing trivia. Peep is co-hosting today. Absolutely. Peep, I just threw him over on his chair. He bounced off. All right, so let's do this. I will take this screen down, and then I will bring up your towel trivia. Now, as a reminder, if you missed it yesterday, towel trivia yesterday went to Allie and Rue. They might be sleeping because it's Sunday. That's okay. That's all right. We don't fault them. We don't fault anyone for taking the day off on a Sunday. It is the Lord's Day, and I am a towel. I got my Virgin Mother pin on. See what I mean? Oh, where is it? There it is. I'm a little towel. All right, so bring it up. All right, come on now. I did have it loaded. I just forgot to expand the window size. See what I mean? We can't play like that. You can't see half the questions. All right, there we go. I really enjoy towel trivia. We've played this for, 6 months or so now. We're on round 31 today. All right, so I'll keep track of your scores. And, yeah, there you go. Oh, I think you're going to do well today, Shannon. Shannon was playing well yesterday. I think it was one of her first appearances. Kick butt, take names. That's my theory on it all. And my name's Grant Smith Ellis. If you're just tuning in, you didn't miss reading through the new document that went up in the Karen Reed and John O'Keefe civil case. You'll want to just scroll back, all right? If you're not here to play trivia, you want to watch that. You didn't miss it. We went through it in depth. I had a lot to say about it. Go ahead and watch that. But we got to play some trivia because I got to get out of here soon. I have a cutoff again today because I want to go eat lunch again, all right? I wanted to hang out with you all in the morning. Wanted to talk about how predatory tactics on the internet to induce emotional reactions in people with false information. We did that. I think I drove Benny Blanco away because he wouldn't answer the question about whether he knows Kate. And now, here we go. I don't want to brag, but who do you think said to Grant one day you should do trivia? It's true. It was not Bella, although Bella's definitely going to take credit because she's in the kiddie CIA. It was bossy Texas chick with Bella right by her side. That is where trivia came from. All right, we're doing the daily challenge to get warmed up. Let me just get the scoreboard going. Hold on. So yesterday, as I mentioned, was round 30. If you want to hear the scores from yesterday, Allie was in first place wearing the crown, 17 points. Little Towel had 16 points in second place. Nicola, I found out we might have two Nicola M's. One of them's from London, one of them's from Scotland. That's why I got confused. Sorry about that. To the Nicola M from London. Nicola was in third place, rounding out the podium, 13 and a half. However, right behind Nicola, right behind Allie Towel and Nicola was Ange with 11.5 points in fourth. Nancy Towel in fifth with 10 points. Jay Towel in sixth with 9. Excellent job, Jay. Extra bonus points for being a friendly towel. Seventh place, Bunny Towel, serendipitously enough, 7.5. Pete Bunny Towel was happy with that. Eighth place, Bossy Texas Chicken Bella, 6.5 yesterday with extra bonus points for being musically talented. Shannon came in with 5 points and Nunya with 1. All right, so towel trivia round 31, and it is 11, 23, 25. Okay, little towels. Let's do it. The way the daily challenge category works is it's random questions, so I can't tell you what this is going to be about. We can't even do a video because I have no idea. It could be about ice cream. One time it was about, French fashion. I was completely baffled. It was like when they were asking about the Ottoman sultans from the 1400s. I was just baffled. No, Shannon, I understand. You still competed well, though. You held your own, and the way trivia works is you jump in, you jump out. This won't be a long day, but it's still fun to play, still fun to learn. I guess I have my own hosting style, Bossy Texas Chick, but it is fun. Then Pete Bunny Towel, of course, has played a big role in the in towel trivia. He really does a good job keeping away the commies, you know what I'm saying? None of the damn commies are coming into towel trivia. You come in here to declare yourself a commie, I'm exiling you to Siberia. You want to be a communist? You'll find out why Kessler wrote Darkness at Noon. Good morning, troll in the north. Good job. You'll get caught up on the civil filing. When you're live, you just let us know because you can play trivia with us. All right, let's begin. Daily challenge, 10-second countdown. Here you go. Call for towel trivia, ladies and gentlemen. I got to give a little bit of a call, otherwise people will say you just started the round while you were ranting about Arthur Kessler's Darkness at Noon, Grant. You can't do that. You can't just start the round when you're ranting because I won't be ready to play. Well, that's true. All right, here we go. Let's do it. Beginning the day. Daily challenge, 3, 2, 1. Answer 1, 2, 3, or 4 in the chat. Whose debut single, Fallen, a soulful, piano-driven ballad, spent 6 weeks at the top of the Billboard Hot 100 in 2001? Was it Alicia Keys? Was it Beyonce? Was it Mariah Carey? Or was it Jennifer Lopez? Whose debut single, Fallen, a soulful, piano-driven ballad, spent 6 weeks at the top of the Billboard Hot 100 in 2001? Are you fallen? In and out of love? With Towel? Can you just not help it? It's Alicia Keys, little Towel. Answer 1. Towel gets a full point. I knew that. Who else? Who else? Oh, Shannon coming in with the full point. Strong start, Shannon. Nancy, my dear friend, it's great to see you. Half a point. Bossy Texas Chicken Bella coming in with half a point. They remembered Alicia Keys. Mr. Cossy G, strong start. Great to see you on the board for the first time. Half a point. Who else do we got? It's Bunny. Bunny coming in with half a point. Excellent job, Bunny. Yes, oh, it's quick. It's Quick Draw McGraw sometimes, no doubt about it. And you can join in any time, by the way. You can just start picking up points. So if you're just getting acclimated to the game, if you want to try it, it's kind of fun. You know what? It's fun. The points don't matter, but Towel does. See how I flipped that around, Bossy Texas Chick? Let's go. Next question. Which California National Park features Ribbon Falls, which is nearly 10 times higher than Niagara Falls? Is it Yosemite National Park, Sequoia National Park, Joshua Tree National Park, Redwoods National and State Parks? Which California National Park features Ribbon Falls, which is nearly 10 times higher than Niagara Falls? Okay, so the only one I know of those that's in California is the Redwoods. I feel like it could be the other one, but I'm just guessing. Yosemite's in California? I thought it was in like Montana. Is this question wrong? Can we double check this, please? I was 100%. I thought Yosemite was in like Montana, or at least more central in the country. Bunny comes in with the 2 points, but can we please do a fact check? Bunny still gets the point, but I think we have to fact check. Is Yosemite in California? Hold on. Where is Ribbon Falls? That, first of all, let's start there. Ribbon Falls. Oh, Yosemite National Park is in California. Wow. I never would have known that. I really thought it was in the middle of the country. Well, there you go. Bunny has put us all to shame. And Bossy Texas Chickabella also got it right. Excellent job. That was a hell of a job, folks. I really thought, and maybe I now have learned something just playing the warm-up round, Yosemite National Park also is in California. I was convinced that it was like in Montana. Maybe because I associate it with NORAD or volcanoes. Hell if I know. Anyway, all right, let's go. Next question. I'm giving it a thumbs up because somehow it was right. Oh, you can't rate the daily challenge ones, but that was a good question. Next one. As of 2025, sorry about that, what MLB team is placed second in overall wins of the Fall Classic, which is the World Series? Is it the St. Louis Cardinals, the Boston Red Sox, the Los Angeles Dodgers, or the Chicago Cubs? As of 2025, what MLB team is placed second overall in total wins for the World Series? Well, we know Yankees have 27. I want to say it could be the Sox. It might be the Cardinals, though. They had a run in the 40s and 50s at Sportsman Park. I'm going Red Sox. Damn it, I told you the Cardinals had a run in the 40s and 50s in Sportsman Park. But listen, I don't care if the answer is wrong, I'm picking the Red Sox. I'm not picking the Cardinals. No chance. If the Red Sox are an answer, I'm picking the damn Red Sox. I'll lose the points. Nobody got it. I see nobody knew about Sportsman Park in the 50s and 60s. I'm telling you, they had a team, folks. I'm telling you, them St. Louis Cardinals back in the 50s, folks. Cossy G was like, I just went for the home team. Me as well. All right, so far, and we don't have Allie playing right now, so no one's playing tactically, so no one got it right. The St. Louis Cardinals, I'm sorry to tell you, no one knows that you are the second highest decorated World Series champion. We all think it was the Red Sox. All right, next question. What Nintendo gaming system, Bossy Texas Chick, you guessed twice on that one. What Nintendo gaming system with game-changing motion controllers and an addictive sports game became a mega hit in the fall of 2006? Was it the DS Lite, the GameCube, the Switch, or the Wii? What Nintendo system with game-changing motion controllers and a sports game became a mega hit in the fall of 2006? Well, those are all Nintendo consoles, but I'll tell you, it was the Wii. Folks, it was the Nintendo Wii, and I got a full point. All right, who got this one? Bossy Texas Chick, she was on this one, full point. And then Bunny coming in with half a point. Who else? Cossy G coming in with half a point. Excellent job. Nancy, good guess. The GameCube was out around that time. It didn't really have motion controllers like the Wii, though. Learning a lot. This is a very hodgepodge category. We are all over the place with this one. It is just jumping us around. About half of you got that one right. That was pretty hard. That was not easy. Next question. Bunny, it does look like you are out to a lead, by the way. Keep it up. Mr. Cossy G, I got your answer. Next question. What energy drink sponsored the highest skydive ever made, a free fall from 24 miles above the Earth in 2012? Was it Rockstar, Monster, Gatorade, or Red Bull? I remember, I watched this. The dude leaned out of the capsule and just fell in a spacesuit. Which energy drink sponsored the highest skydive ever? I'd really call it like a space dive. A free fall from 24 miles above the Earth. And obviously, it was not Gatorade, folks. I'm telling you, it was Red Bull. It was Red Bull. I got it right. I'm a little towel. 4 was the correct answer. Mr. Cossy G, your first full point. Excellent job. You nailed it. Mr. Cossy G, the 508, also knew it was Red Bull, coming in with half a point. All right, excellent job. Excellent job. A lot of good guesses. Could have been Monster. Let's go. Next question. Which designer wore a plaid skirt while taking his congratulatory bow at the end of his fall show in New York City in 2008? Was it Vera Wang? I thought that was a woman. Ralph Lauren, Michael Kors, or Marc Jacobs? Which designer wore a plaid skirt while taking his congratulatory bow at the end of a fall 2008 New York City fashion show? I don't know. Ralph Lauren? It was Marc. How would I know that? Why would I know that? And I think Vera Wang's a woman. I just want to say. All right. Shannon coming in with the full 2 points. Excellent job, Shannon. I got that one wrong. Who else, ladies and gentlemen? Who else knew that it was Marc Jacobs? Did anyone guess? Am I right? Is Vera Wang a woman? Why? I feel like Vera Wang is a woman. I don't want to misgender Vera Wang. I just don't feel like it could have been the answer. So Shannon was the only one to get that one right. That was not easy. You know what I'm saying? Now, Bunny, that was a good guess, but it did indeed turn out to be number 4, Marc Jacobs. I thought Marc Jacobs, well, why do I associate him with Jay-Z? I don't know. Anyway, that was the end of that round. Shannon was like, Shannon is pleased. Yes, okay, Vera Wang is a woman, so at least I knew that. I ruled out an incorrect answer. Now let's take a look at the scores. Some scores from yesterday, some scores from today. All right, there are the scores for today. Here we go, folks. I'll tell you the scores. The scores stand as such. Oh, got to move Bunny. Oh, Bunny, you barely held on to that lead, but Bunny Towel, ladies and gentlemen, let me get Pete. Pete, 5-1-3. Bunny is in the lead. She may take the crown today. Allie's not playing. I'm telling you, Bunny's got a strong chance, but it is anyone's game. Bossy Texas Chick, you guessed twice on that last one. I'm smarter than that. I got Pete with me. All right, here we go, folks. I got to move 2 more people around. So I got to move Nancy, and then we're good. All right, here's the scores. In first place after the first round of Towel Trivia today on this relaxing Sunday, we have Bunny Towel. Pete Bunny Towel is losing his ever-loving mind. He knows Bunny hates the communist, and Bunny Towel is also in first place, 3.5 points. Now, Bunny Towel can't get too comfortable because Bunny Towel has some ferocious competition, including Towel and Shannon, both tied in second place with 3 points. So, Bunny, you can't look back even for a second. You might trip, stumble, fall, and cause some type of global conflict because clearly you and Pete Bunny Towel are going to take down the damn commies. In third place, excellent job. They're on the podium. Ladies and gentlemen, do not sleep on Bossy Texas Chicken Bella. Literally, don't sleep on them. I think Bella will attack you. Anyway, they have 2.5 points. Excellent job, Bossy Texas Chicken Bella. Bunny says it's a Sunday pre-Thanksgiving miracle. Yes, it is. Yes, it is, says Pete Bunny Towel. He's excited for lettuce. I thought you wanted... Oh. He says he's also okay being around turkey, but he doesn't really love turkey. He feels it's a little bit of cannibalism. He prefers lettuce. He thinks lettuces aren't actually sentient, so he can eat them. I didn't know you have very strong feelings. Well, I guess cannibalism, like for you, is any animal. Oh, I see. Pete Bunny Towel is an herbivore, so he feels very strongly about this. He doesn't eat any animals. He says that that's cannibalism, bunny cannibalism. What if they're not bunnies? Oh, you're a bunny, so you'd be a... Oh, yeah. He says all of the species of the earth are his fellow creatures, and he doesn't eat them. That's a very noble stance for you to take, Pete Bunny Towel. For a man who, Pete Bunny, who really dislikes communists, you're very compassionate. Oh, it's because the communists are not compassionate. Understood. In any event, great job, Bossy Texas Chick and Bella. 2.5 points, rounding out the podium. One of their first times on the podium in a while. Don't sleep on them, though. Literally, Bella will bite you. I said that twice. Right outside the podium, their first appearance in Towel Trivia after round 1. We're just getting started here today. 2 points. Fourth place, Mr. Cossy G. Excellent job. Pete Bunny Towel is proud of you. Good job. In the position of honor, 5th place today, 1 point after the first round. But again, Nancy can climb up quickly, so do not allow her any wiggle room. I'm telling you, I've watched Nancy climb up that leaderboard before. Pete Bunny Towel's telling me in my ear that she's going to do it. Nancy in the position of honor, 1 point. All right, Pete, next round. Thank you for your well wishes. Everyone loves you very dearly. Peep says he loves you all too. All right, here we go. Give the bunny a carrot. Yes, he likes lettuce. We'll try carrots too. All right, let's go to the next round. Next round, what are we going to do? All right, let's do a vote. All right, throw some suggestions in the chat for categories and we can vote on them. If you have category suggestions, if you're here to learn, if you want to play, jump in at any time, but let me know your category suggestions. I can't buy a bucket today, okay? So Nunya's category suggestion is buckets, clearly. But go ahead and throw your category suggestions in the chat. I know a lot of you have ideas percolating around on this, the first day of the Thanksgiving week. We got a lot of holiday spirit and cheer going around, and I'm excited to be playing Towel Trivia with you all. But yes, it takes about 20 seconds for them to actually hear me say this. Music is one of the category suggestions. Next Towel Trivia round, music. All right, what other suggestions? Massachusetts. The tribe or just the state? Massachusetts. Rap music. Okay. Can Kate Peter be a category? How much does Kate Peter suck? Football. Oh, Austin Powers. All right, hold on. We'll put Austin Powers on the list for the next round. All right, closing off the categories, folks. Here's your vote. Go ahead. Now, Bunny, we might get soccer questions, just so you know. Indigenous habits of the Iroquois. Okay, we can do that as well. Habits of the Iroquois. Okay. Go ahead and vote away. We'll allow a few votes to come in. We'll see what folks want to do for this round of Towel Trivia. Give it a second. It has to load up the poll. All right, it's loaded up. Are we going to do music, Massachusetts, rap music, or football? I guess there's a little redundancy there, but rap music's a little more precising. Music's out to an early lead, ladies and gentlemen. People like the generalized categories. We're going to get to 10, 15, 20 votes, depending on how I'm feeling. Got a decent amount of people playing and watching, so we'll let the counter go up. It's tied right now. Music in Massachusetts, 40% each. Rap music falling behind. Football, 0%. Nunya, that is not a vote. You must actually vote. We have to go by the votes on the screen. All right. Oh, it is still very close here, folks. It's very close. Mr. Cossy G, you got the Nintendo question right. Did you get it first, or did you get it right in general? If you got it right in general, and I got it right, you get half a point, unless you were first. I believe you may not have been first. I don't remember. I'll give you half a point anyway in good faith. Christmas rap. Nunya, is that even a thing? All right, what do we got on the poll results here? All right, I can't close the poll. It's a tie. I could flip a coin. That'd be kind of fun. All right, I'm flipping a coin. No, I ended the poll. The final results are thus. What do we got? Here we go. Ladies and gentlemen, we have a three-way tie. Oh, this is incredible. We've never had a three-way tie. We're going to have to do some kind of bracket. Music, 29%. Massachusetts, 29%. Football, 29%. Okay, so here's what we're going to do. We're going to have to do this the fairest way. We're going to have all three of them compete. I don't have a three-sided coin or a three-sided die, so we're going to have a 1 seed, a 2 seed, and a 3 seed. Music is the 1 seed. They get a bye. Massachusetts and football are going to play off. All right, here we go. I'm assigning Massachusetts heads and football tails. Who will advance to the championship round? It is tails. Football advances to compete against music in the final round. Here we go. Will it be music, heads, or football, tails? Here we go, ladies and gentlemen. It is tails. Football comes from behind. They went through the wild card round. Somehow football has won. Bunny, it started off at 0%, and you competed through the first round. You got past the team with a bye, and football is the category. Everyone congratulate Bunny. Excellent job. Good job, football. All right, here we go. Football is the category. Who knows what this is going to lead to, ladies and gentlemen? It could be about European football. It could be about American football. It could be about putting your foot on a ball. It's a barn burner indeed. All right, 10 seconds till the next category. Give you a fair warning here. 10 seconds till the next category. Bunny is so excited. Bunny's like, I have been redeemed. The coin flip made it happen. Nunya is pleased with the category suggestion, as am I. All right, here we go, folks. Here we go. Football. 3, 2, 1. Let's do it. What is the name of the trophy awarded to the NFL champion? Is it the Stanley Cup, the World Cup, the Lombardi Trophy, or the O'Brien Trophy? What is the name of the trophy awarded to the NFL champion? Is it the Stanley Cup, the World Cup, the Lombardi Trophy, or the O'Brien Trophy? Ladies and gentlemen, the Green Bay Packers, one of the greatest teams of all time, one of the greatest coaches of all time, Mr. Vince Lombardi himself. Oh, you're all in trouble for this category. Towel knows a lot about football, let me tell you right now. Who got number 3 right first? It was Nunya. Look at that. Nunya storming onto the board with a full point. Who else? Nancy, look at everyone knows the NFL category. We're all in for a lot of trouble here, folks. I'm telling you, we're all very smart about this. Let's see if we get some challenging questions. Shannon got it. Bunny got half a point. Bossy Tex Chicabella, half a point. And Mr. Cossy G, half a point. Excellent job. Let's see. Brian, there you go. Excellent job, Brian. Welcome to the chat. You also get half a point. Brian, welcome to the game. Thank you for playing with us. It's really fun to learn, and we're glad to have you. Go Patriot, says Nancy. Yes, triple header for New England sports today. You got the Pats at 1, you got the Bruins at 6, and you got something else, Celtics or something at 8. I don't know. There's 3 sports games on today. I'm going to watch the Patriots while I'm eating lunch, but I got some errands to run, which is why we're playing trivia, and then I'm going to close out the stream. We'll come back tomorrow and talk more about other things. For today, we're going to keep playing trivia. All right, next question in the NFL category. Who's excited? I'm excited. It is Thanksgiving week. Let's do it. I'm your host, Grant Smith-Ellis, and I'm a towel. Which country won the 2022 FIFA World Cup? Oh, damn. Was it France, Brazil, Germany, or Argentina? Which country won the 2022 FIFA World Cup? France, Brazil, Germany, or Argentina? Wasn't Argentina. I want to say it was Germany or France. Was it Mbappe? I think it was France. I don't think it was Brazil. It was either France or Germany. I'm going France. It was Argentina. I didn't know Messi had a World Cup. Messi won a World Cup? Wait a minute. Wow, so it's Ronaldo who doesn't have one. It was Argentina. I didn't really watch that World Cup. Wow, so the answer is number 4, Argentina. Now there I was thinking Messi and Ronaldo didn't have any World Cups. I guess Messi did get one. Nancy from the 508 picks up a big 2 points. Now listen, I told you, Bunny, this could happen. It thinks football is also soccer because on the internet, the word means both American football and soccer. Excellent job. Well, don't do that, Cossy G, because Brazil got absolutely smoked by Alemania in 18, like 7-1 or something, bro. They got like humiliated. So no, I wouldn't put a lot of faith in Brazil. I mean, they got Neymar and stuff, but really they're not the strongest national team. Germany's very strong. France is too. They have Mbappe, but I guess Argentina was the one that pulled it off. And Argentina did in 2022. They did have, like, for the first time, like a decently strong line. I think also some of the City players, Aguero played for them. Like, they had a good generation, so I can see why they won. Thank you, Bossy Texas Chicabella, for supporting Towel Stream. Bunny, exactly. I don't watch it either. I used to watch a lot of Man City, not as much anymore. Nancy says football is soccer in Spain. Entiendo español, Nancy. That is indeed true. Mr. Cossy G is like, I know I'm a man of advanced years. All right, next question. In which year was the offside rule introduced in football? 1863, 1888, 1904, 1891. This is European football again. In which year was the offside rule introduced in football? 1863, 1888, 1904, 1891. I have no idea, bro. 1891, 1904. I don't know if it's a new invention. I'm going 1891. Nope, it was literally invented at the beginning of the game. 1863. Who got that last one right, by the way? I think there was only one person. Nancy, so I got to make sure Nancy gets double points. Hold on. I think you did. You did, Nancy, indeed. You got your 2 points. All right, who's going to get this one? It is 1863. Nanya, were you alive back in 1863? You want to tell us about what it was like? The Civil War was raging. Abraham Lincoln probably called over to the British Prime Minister and said, "Sir, if you're going to play that ball game, you must introduce a rule against offsides." Nancy nailed it again. Double points, ladies and gentlemen. I told you, you cannot close your eyes for 1 second. Nancy is now in first place. We have all just been humiliated. Hang out in front of the last defender and get called for offsides. Nanya, you can't be offsides in your own half, as Fernando Torres exploited to his benefit when Chelsea won the Champions League final in 2013 against Barcelona. Can't be offsides in your own half. And you can't be offsides on a direct kick from the goalie. All right, next question. Yeah, the soccer questions are hard. But, Bunny, I knew this was going to happen. I even predicted it. Next question. Which football club is known for the famous class of 92? Was it Liverpool, Barcelona, Real Madrid, or Man United? Was it Liverpool, Barcelona, Real Madrid, or United? I think it was Fergie. I don't think Liverpool was good in 92. I think it was Fergie's club, and he had some freaking bosses like Paul Scholes and some of those guys. I'm going United. I got it. It was Alex Ferguson's United club. They were beastly. They were just like, he dominated like the top flight before financial doping really came in. Ferguson was a boss. I knew some of the dudes. I was naming some of... That was Roy Catatonia or whatever his name was. The dude who literally ninja kicked. Want to talk about Leah Bathtub Genduso's ninja fantasies? That dude ninja kicked a guy in the stands because the guy was mean to him. The mother effer runs over to the side of the stands, jumps up over the ad boards, and just ninja kicks a dude. It was great. They were outrageous back then. Great job, Bunny Towel. Bunny picks up a full point. We're still behind Nancy Towel, though, Bunny. I'll tell you that. All right. A lot of soccer questions. These are hard to answer. I'll admit that. Next question. Which player holds the record for most goals in a single World Cup tournament? Which player holds the record for the most goals in a single World Cup tournament? Is it Pele, Cristiano Ronaldo, Diego Maradona, or Just Fontaine? Okay, I think it was Pele, but I think Maradona might have matched it. Oh, damn. It's either Maradona or Pele. I'm going Maradona. Who the hell is Just Fontaine? I don't even know who that is. All right, let's see if anyone gets number 4 here. Double points up on the board if you get number 4. I don't know who Just Fontaine is. I'll be the first one to admit that. I have no idea. Bathtub Ninja, should I be concerned? Ladies and gentlemen, Nancy picks up another 2 points. We're all in a lot of trouble. She is just wiping the table with us. Absolutely just wiping the table with us. We're learning, but she's wiping the table with us. All right, next question. That was a hard one. Which nation first hosted the UEFA European Championships? Was it Italia, España, Alemania, or France? Italy, Spain, Germany, or France? I have no idea. European Championships? I would think Italy or Germany. Maybe like to celebrate German reunification. It was started in the 80s or 90s, didn't it? I'm going Italy. It was France. Damn Frenchman. Nope, none yet. Your strategy failed yet. It was France. The damn Franks. This is a hard category. Bunny, you inadvertently set us down a path to European greatness. Watch Nancy. Nancy's going to come in. There you go, ladies and gentlemen. Nancy has pulled an alley towel and wiped the floor with us. Bunny picks up another point, but Nancy gets the double points. All right. That's the end of that category. I'm sorry, Bunny. I started off excited. By the end, I was just sad. All right, here's your scores. We have a new leader. Ladies and gentlemen, she is so far out of the pack, you may as well just give her the title now. I don't even know if we can come back from this. We have all just been decimated. Well, Bunny, you may regret it, but Nancy is celebrating right now. Baggio, Roberto Baggio on Italy. Yes, he was a great player, even though he missed the kick. All right, Pete Bunny Towel, would you like to announce our new first place contender? She is a very strong, very intelligent super towel. Pete Bunny Towel said he's very proud. Nancy, maybe for the first time, I don't know if she's won before. Nancy is on the podium. She is wearing the crown after our second round. 9.5 points. Congratulations, Nancy. That was a very resilient round. You picked up a lot of points, as I predicted. Nancy went from 1 point to 9.5 points in one round. I literally said, just watch what Nancy's about to do to you all, and then she wiped the floor with you. Nancy's like, I'm doing my best. You're doing more than your best, Nancy. You, Pete Bunny Towel, is singing your praises. You are wearing the crown. 9.5 points. Our new leader after 2 rounds. In second place, it's Bunny Towel. Pete Bunny Towel, every time he sees Bunny Towel, he just starts hippity-hoppiting, yelling about the commies, how he loves America, and then he was like, Bunny Towel's here. 6 points, second place, on the podium after 2 rounds. Bunny Towel, excellent job, Bunny Towel. Third place, he counts, but his points don't. He's a little towel, rounding out the podium, fighting hard, doing my very best. Towel, behind Bunny Towel by 1 point, 5 points. Now, right off the podium, ladies and gentlemen, we have a very close competition. We have Shannon in 4th place. Shannon, you're right outside the podium position, 3.5 points. Excellent job again. Second round of towel trivia for Shannon. In 5th place, we have a 2-way tie right behind Shannon with Bossy Texas Chick and Bella, who's in the Kitty CIA. 3 points, and Mr. Cossie G in his first appearance in towel trivia. 3 points. Excellent job. 5th place. 6th place, we have the one and only Nunya Towel, captain of the good ship Nunya. Pete Bunny Towel says, keep driving that boat. 1 point. And in the position of honor, Brian popping up on the board for his first time. Thanks, Brian, for playing. 0.5 point. 7th place. Excellent job. All right, Pete Bunny Towel, we're going to our next category. Okay? Okay. I hate the commies, too. Oh, you're very kind. He says he loves you all very much. He'll be back soon. He just hips, hops, and there he goes. He's my co-host today. He's my co-Pete Bunny Towel. All right? He's a Pete Bunny Towel. All right, next category here. What are we going to do? Let's do a double bonus category. Who's ready to learn? Who's ready to learn? I'm ready to learn. Part of this is we do a double bonus category, and to give you a fighting chance, I put up a video. All right, let's do a video on the good ship Bodie McFloats. Nunya's like, I'm the captain of the good ship Bodie McBoatface. All right, let me pick a category here. How about, oh yes, about the rules of civil procedure, and then I'm going to ask you questions about it. All right, I found a 7-minute video from Silicon Valley Business School, and we're going to use it to then answer questions. Let's see. All right, here we go. I found a video. We're going to watch. I have no idea where this is going. I promise you, it's for educational purposes. In the sense that they could say random things. But we're still going to use it, and then our double bonus category is going to be the Federal Rules of Civil Procedure, so get your towel notepads out. Otherwise, you might get questions wrong. All right, let's do it.
The Principles and U.S. Federal Rules of Civil Procedure. Civil procedure is the body of law that sets out the rules and standards that courts follow when adjudicating civil lawsuits, as opposed to procedures in criminal law matters. These rules govern how a lawsuit or case may be commenced, what kind of service of process, if any, is required, and types of pleadings or statements of the case, motions or applications, and orders allowed in civil cases, the timing and the manner of depositions and discovery or disclosure, the conduct of trials, the process for judgment, various available remedies, and how the courts and clerks must function. Early federal and state civil procedure was rather ad hoc and was based on traditional common law procedure, but with much local variety. There were varying rules that governed different types of civil cases, such as cases at law, or in equity, or in admiralty. And these differences grew from the history of law and equity as separate court systems under English law. Even worse,
So basically, a court of law is where you're asking the court to apply like statutory power, and then a court of equity is where you're asking the court to do everything else. Those two joined in 1934. That's the basic premise there of what civil law is. And then the admiralty law thing, I don't even want to go down that road. It gets very complicated.
Discovery was generally unavailable in actions at law. In order to obtain discovery, a party to a legal action had to bring a collateral proceeding, a bill in equity in aid of discovery, just to obtain essential documents or testimony from the opposing party. The Conformity Act of 1872 directed federal courts to conform to the civil procedure of the states in which each federal court was located as much as possible, though federal courts were allowed to continue to develop the federal common law of evidence, most of which was replaced a century later by the federal rules of evidence. However, state civil procedure law continued to diverge, particularly when some states, but not others, began to replace common law pleading with code pleading. The inevitable result was confusion and chaos in the federal courts, particularly as interstate commerce escalated with the Second Industrial Revolution, and an increasing number of cases between citizens of different states were heard in federal courts under diversity jurisdiction. Therefore, the United States federal court system adopted standardized federal rules of civil procedure in 1938, which unified law and equity and replaced common law and code pleading with modern notice pleading. Most states have also adopted the federal...
That was saying, like, you don't ambush people anymore. You notice pleading. You give them notice.
rules to govern civil procedure in their state court systems. Although significant modifications were necessary because the federal courts are courts of limited jurisdiction, while state courts have general jurisdiction over innumerate types of matters that are usually beyond the jurisdiction of federal courts, such as traffic, family, probate, and so on. A few states have adopted the general principles that civil procedure should be refused to adopt the FRCP, Federal Rules of Civil Procedure. For example, Rhode Island has its own civil court rules of procedure. California and New York are the odd exceptions in that almost all of their civil procedure systems are codified in statutory law, the Code of Civil Procedure and the Civil Practice Law and Rules respectively, not in rules promulgated by the State Supreme Court or the State Bar Association. Civil procedure involves the selection of an appropriate court to hear a particular case, and following certain procedures when dealing with the court and other parties. In selecting an appropriate court, there are three important factors to consider. The court must have jurisdiction over the parties, must have jurisdiction over the subject matter of the case, and must satisfy rules regarding venue. Venue refers to the selection of the most appropriate county or district to hear the case. After the court has been selected, and there may be several alternatives to choose from, the parties must follow the appropriate procedures regarding service of process, the complaint and other documents forming the pleadings, the joining of multiple parties and claims, the sharing of evidence and other information in the pre-trial discovery phase. Certain rules must be followed with regard to how prior judgments, often judgments from other courts, affect the case in hand. Then when it comes to trial, there are established rules to determine all aspects of the trial and the subsequent appeals. The U.S. Constitution creates a federal system of government in which power is shared between the federal government and the state governments. Both the federal government and each of the state governments have their own court systems. The judicial power of the United States is vested in the federal court system. The Constitution also creates the U.S. Supreme Court and gives Congress the authority to create the lower federal courts. Every state in the United States has its own court system to hear cases arising from that state. Suppose that a citizen of Mississippi sued a citizen of Alabama in a case involving a real estate transaction that took place in Georgia. The case could be brought in state court in Mississippi or Alabama because of where the parties live, or it could be brought in Georgia because of where the property at issue is located. However, such a case could not be brought in the state of Alaska because none of the parties live there and the state of Alaska has no attachment to the case at all. The Alaska court would dismiss any claims in this example because it would not have the appropriate jurisdiction. No federal court has subject matter jurisdiction to probate a will. The probate process has traditionally always been left up to the individual state courts. In contrast, cases involving patent gives Congress the specific power to regulate the patent system. State courts do not have the appropriate jurisdiction to hear patent cases. Federal courts also have exclusive subject matter jurisdiction over copyright cases, admiralty, lawsuits involving the military, immigration laws, and bankruptcy proceedings. However, in most other matters, state and federal courts hold concurrent subject matter jurisdiction. Claims arising under federal law may be heard in either judicial system. Both plaintiffs and defendants may choose between state or federal. A defendant has the general right to remove both federal question and diversity cases from state to federal court. However, only a non-resident may remove a diversity-based state law claim to federal court.
Okay, so it's Pete Bunny Towel. Yes, indeed, Pugs Over Drugs. And Jay, Pete Bunny Towel, Jay said he's going to make you a special towel. You are a towel, and he wants to make you a towel. Very meta. He's very grateful. He is a Pete Bunny Towel. He's poking his head up. He's just saying hello. He hates the communists, and he's excited for our next round, which is going to be a double bonus round on the federal rules of civil procedure. Oh, we're playing now, Jay. We are heading into our double bonus round. Stream ends today in about half an hour, 45 minutes, but we're closing it out with trivia. I'll be back tomorrow to say more things about other things. Look at little towel. He's being a little Pete Bunny Towel. All right, let's do the next round. All right, it's going to be the federal rules of civil procedure, and this is a double bonus round. All right, this is going to be an exciting double bonus round. I will give you a point update. All right, you want to see a point update? There it is. We have Nancy Towel leading the pack, 9.5, first place. Bunny Towel, 6 points, second place. Towel, 5 points, third place. Shannon, 3.5 points, fourth place, excellent job. Fifth place, Bossy Texas Chicken Bella, 3 points. Sixth place, tied actually with Mr. Cossy G, fifth place. Sixth place, Nunya with 1 point. Seventh place, Brian with half a point. Allie and Bro, you made it just in time. We might have a little buffering going on. That's all right. I'll wait for it to settle down. It's kind of stormy here today. It was going to snow at some point. The weather's been actually really bad the past 2 days. It was like raining, then incredibly cold, and then it's supposed to snow. Anyway, good to see you, Allie and Rue. Everything seems to be going fine. Let us get ready for our next round of Towel Trivia. It's a double bonus round. Federal Rules of Civil Procedure. Let's do it. Rue, Toffee Towel, how are you all doing? Pete Bunny Towel's excited. He says you're going to do great in this round. 3-second countdown. 2, 1. Let's do it. I got to select the bicycles. I did so. Here we go. Oh, you'll do great, Allie. You got this. What is the primary purpose of Rule 26? Sentencing, jurisdiction, remedies, or disclosure? I have no idea. Disclosure? Disclosure. Yes, I got it right. With 1 second to go. I used my book. Using your book is not cheating if you literally have a book. It's disclosure, ladies and gentlemen. Rule 26. Who knew? I haven't touched this book in like 3 years. I got it right. I'm a little towel. I'm so proud of myself. Hold on, where's that? Rule 26. Let's see what this says here. All right, let me read a little bit about it here. Hold on. Rule 26. Discovery devices. This is a new subdivision listing all of the discovery devices provided in the discovery rules and establishing the relationship between the general provisions of Rule 26 and the specific rules for particular discovery devices. The provision that the frequency of use of these methods is not limited confirms existing law. Okay. Oh, wait a minute. Let me see. It's discovery devices. It's the most appropriate rule for that purpose. All right. Allie, there was a lesson video, but it would not have helped you with that one. All right, who got it right first? Bunny, excellent job, Bunny. You got a full point. Sorry, I was reading my rule book. Allie, Towel, and Rue get half a point. Good job, Allie. Nancy from the 508, another half a point. And then J Towel on the board, half a point. See what I'm saying? It benefits you if you just have the federal rules of civil procedure. Joe. All right, let's see. I'm going to pause for a second. Oh, it's buffer. No, we're back. Jay's like, I have cramps. All right, Jay, well, you don't get half a point for having a cramp. Next question. Which rule governs summary judgment? Oh, dear God. Rule 23, Rule 56, Rule 11, or Rule 33? What's Rule 23 about? Rule 23 is class actions. Is Rule 56 summary judgment or Rule 23? How am I supposed to know this? Oh, God, this is really hard. I'm going Rule 56. It was Rule 56. I got it. I didn't even find it in the book. I just guessed. All right. I'm a good job, little towel. The answer is number 2. Jay absolutely nailed it. Jay gets a full point there. Can't blame him for that. Excellent job, Jay. Who else got number 2? Bunny Towel knows her rules about summary judgment. Excellent job. Bunny Towel, half a point. Nancy picks it up. Excellent job, Nancy Towel, half a point. Allie and Rue picking up another half a point. All right. Yes, keep your handy-dandy federal rules of civil procedure close. Which rule addresses the timing of motions for a new trial? Rule 59, Rule 51, Rule 41, or Rule 43? Motions so helpful for this. A new trial motion, 59, 51, 41, 43. It's 59. I got it right, little towels. I did my research. It is number 1. Jay picking up another full point. Jay clearly knows his federal rules of civil procedure. Okay, who's going to know this one? Nancy picks up another half a point. Nanya picks up half a point. And Allie and Bro pick up another half point. All right. You are? Oh, Allie, you're buffering? One sec. I'm buffering too. Could just be the interwebs. Give it a second. We should be back. Jay, you certainly know your stuff. Maybe you're someone... Maybe you're not who I thought you were. Maybe there's another Jay. Jay, by the way, there's a lot of Jays, so if you're a different Jay than another Jay, it's impossible to tell. But yeah, you know your stuff, Jay, and you're getting it right. No time to look it up. Allie, the buffering is definitely because of the weather, but we should be slowly coming back into it here. It's been a little annoying today. We're only going till noon anyway. Once I make sure the buffering is settled. Oh, why are you being so frustrating today? Oh, my computer. I see. All right, I got a plan. Hold on. I got a plan. I'm a towel with a plan. Let's see if that'll stabilize it a little bit. There's also other things I can do going forward. By the way, I can reduce the bit rate, which will make the stream more stable. But I'm not going to do that with like 2 categories left. So, all right. I want to just make sure it settles down here. It's pretty settled. Why are you being so frustrating today? I wonder if it's a setting. I might just have it on a very high bit rate. Yep, that's exactly what it is. It's spiking. No. You don't need to be at 5,000. Why are you doing that? I capped you at 2,000. And it's because I set up a new output. I'll deal with it tomorrow. The point is I set my kilobit bit rate very, very high, which might be good for some of you who can handle the stream, but I don't need to stream it at 4K. I'll fix that tomorrow. All right. All right, computer, calm down. All right, here we go. I think that should fix it. Space energy. No, Nanya, it's not. It's my... Basically, what happened is I set up a new stream output, and I told it that I wanted it to be higher quality than I wanted it to. What rule does 12b6 pertain to in legal proceedings? I don't even need to look at the book for this. What rule does 12b6 pertain to? Is it lack of jurisdiction, failure to state a claim, insufficient evidence, or improper service of process? Is it lack of jurisdiction to dismiss for failure to state a claim under 12b6? I nailed it. Towel gets a full point. The correct answer is number 2. Good guess, Jay. 12b6 motion to dismiss for failure to state a claim. Indeed, they were just talking about that in the Canton cases, actually. So the correct answer is number 2 here. And if you're buffering, I apologize for that. I'm going to fix it tomorrow. Nancy from the 508, excellent job, my dear friend. Half a point. No, Jay. Allie, hold on, we've had a challenge. Allie gets half a point, and Buddy B gets half a point. Jay, we've had a challenge. Let me go ahead and pull up my Federal Rules of Civil Procedure. I'm going to go ahead and go to 12b6. All right, that's Rule 10. I would prefer Rule 12. All right, Jay, I am under Rule 12. Okay, Rule 12, definitions and defenses and objections. When and how presented, motion for judgment on the pleadings, consolidated. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. But a party may assert the following defenses by motion. 6, failure to state a claim upon which relief can be granted. So a 12b6 is indeed a motion to dismiss for failure to state a claim upon relief can be granted. The answer was correct. I'm glad we all went through that process together. Who else got it right? I think Nancy, Allie, and Bunny all got it right. Great job, folks. Great job. I think it's really funny that my computer thought I wanted to stream in 4K. No, I do not, computer. I'm glad that you thought you had that ability, but that's unnecessary. All right, that was a great answer. Jay, thank you for challenging the answer, but you result that... No, Jay, it is not improper process. I'm looking at 12b6 right here. Now, just so that Jay can get this correct, Jay, you're just off by 1. A 12b5 is a motion for insufficient service of process. And just to take you through this, a 12b1 is for lack of subject matter jurisdiction. A 12b2 is lack of personal jurisdiction. A 12b3 is improper venue. A 12b4 is insufficient process. A 12b5 is insufficient service of process. 12b6 is failure to state a claim upon relief can be granted. And 12b7 is failure to join a party under Rule 19. All right, so I just want the challenge continues, but Bunny, when you literally have the rules of civil procedure, I just want you all to understand that is anyone under service process. The scope of electronically stored information in discovery. Now, this is probably going to be related to 26. I don't even need to look, because that's discovery in general. But what about electronic discovery? Oh, it's a trick question. Is it 56, 26, 16, or 34? You'd think it would be 26 because 26 is about discovery. But ESI is covered under an amendment which became Rule 34. Oh, I'm a little towel. You can't beat me in this round. You cannot beat me in this round, ladies and gentlemen. No, Jay, you cannot get half a point. You were close, but it's not horseshoes or hand grenades. The answer to this one is number 4. It is a Rule 34 motion for ESI in discovery. A Rule 34 motion, little towels. Jay, you got this one right. That is a good job, Jay. Full point. Allie Towel coming in with half a point. Excellent job, Allie Towel. That was a hard one, because you would think it was the same discovery rule as last time, 26, but it's not. This is a good review. We're learning. The next question. That was hard. That was a hard question. I liked it, but it was a hard question. Here we go. Last question in the double bonus category. I won't use my book for this one. All right. I'll keep it closed. Hold it up right here. Next question. Which rule addresses the consolidation of motions to dismiss in civil proceedings? Is it a 15B? Is it a 12G? Is it a 23D? Or is it 11C? Which rule addresses consolidation? I'm going to guess it's a 12G because motions to dismiss are generally under 12G. Ladies and gentlemen, I used inductive reasoning to get it right. Towel really charged up the leaderboard in that category there. The answer is number 2, 12G motion to consolidate. A 12G motion to consolidate. Bunny picks up the full point. Excellent job, Bunny Towel, picking up a full point. Nancy picking up half a point. Ladies and gentlemen, what about Allie and Bro? Half a point. All right, that's the end of that round. I went 6 for 6. And on the last one, I didn't even use my book, but I got to say, you were up against a force of nature there, ladies and gentlemen. Clearly, I had a lot of that stuff in my mind. It's a lot to remember, but I did it. All right, let's look at the scoreboard. Oh, goodness. Oh, goodness, we have some movement. Some people made some progress. Some people did not make some progress. Some people were just fighting for their ever-loving existence. Here we go, heading into our last round. So our next round's our last round. Why? Because I'm going to eat lunch after that, and I'm not feeling great. Hi, Bunny. You are a Super Towel. You did really well that round as well. All right, let's look at our scores heading into the final round. Let me get Peep Bunny Towel. Peep! Time to announce the scores. We got one more round after this. And then for tomorrow's stream, I'll fix the, we don't need to broadcast in 4K. I will fix that. I'm really sorry. That's not happening right now. All right. Where are we going here? Okay, Pete Bunny Towel, you ready to announce the scores heading into our final round? Yes, I know, computer. I know you cannot do 4K. You don't have to tell me every 2 minutes. In first place, Little Towel. She maintained her first place position. I'll tell you right now, Nancy Towel maintained her first place position. You can see it right there with 12 points. She's wearing the crown heading into the final round, Little Towels. 12 points for Nancy Towel. Excellent job. Excellent job, Nancy. In second place, he charged up the leaderboard that last round, left no points on the table. He's a Little Towel. He counts, but his points don't. 11 points, second place. Right behind Little Towel, though, on the podium, doing really well today. Excellent job, Bunny Towel, coming in with 9.5 points on the podium. Excellent job. That rounds us out. Pete Bunny Towel's here with me. So happy to see you all. Nancy Towel and Bunny Towel on the podium. Excellent job, Shannon. Fifth place, Bossy Texas. Nunya, 1.5 points, steering the good ship Bodie McBoatface. And then seventh place, the position of honor, heading into our last round, Brian, 1.5 points. Today, yes, our last category on the only 4K stream that will ever go live on this channel, because I clicked the wrong button, is going to be Caddyshack, ladies and gentlemen. Jay's been waiting for it. It's our last category of the day. It is Caddyshack. Let me get rid of the scoreboard. All right, here we go. If you've been waiting for Caddyshack, this is your moment. Last category of the day. 5-second countdown. I know it's frustrating. I'll fix it tomorrow. Which animal famously disrupts a golf course in this film? Which animal famously disrupts a golf course in Caddyshack? Is it a squirrel, a fox, a rabbit, or a gopher? Is it a squirrel, a fox, a rabbit, or a gopher? I think it's a gopher, but I'm kind of mixing up Caddyshack and Happy Gilmore, but I think it's a gopher. I got it, Little Towels. It is indeed a gopher. The answer is number 4. Nancy gets the full point. Nancy, you got it. I know it's buffering bad, Allie. I set the wrong. I'm paying the price for setting the stream setting wrong. I'll fix it tomorrow. It's trying to broadcast at higher quality than my computer can do because I clicked the wrong button. I could fix it now, because it's going up to very high bit rates that I don't need to do, but I'd have to pause the YouTube and then come back. So let's just get through this last round, all right, and then we'll have it fixed tomorrow. But yes, number 4 is the answer, and I got everyone so far that answered number 4. Nancy, Bunny, and Allie Towel. Excellent job. Literally watches the stream. Goes up to 7,000. I'm like, no, stop doing that. I wonder if I can fix it midstream. Hold on, I might not be able to. Hold on, stick with me. Yes, that's exactly what happened. Hold on, I fixed it. Wait a minute, I fixed it. Wait a minute, watch this. Watch this. Watch this. Hold on. It's fixed. How's that? So you want to know what happened? Just while we're waiting for folks to catch up, because now I fixed it. I was setting up my stream today, and I was like, oh, I'll just set up a new stream. A little bit more stable now, and the buffering should be gone. I didn't know I could fix it midstream. Sorry about that. No 4K towel ever, and that was also an accident. So, but yeah, when you run your own streams, I don't use like a service. I just like have a software client, and I have to know exactly what I'm doing. Yeah, there you go. I fixed most of the buffering. It's going to take like a little bit for it to fully adjust down, but I reduced the quality of the stream. I shouldn't have done that. All right, but anyway, we're going to the last 5 questions. Where's Jay? Jay, I thought you wanted to play the Caddyshack category. Let's go. Next question. What is the main sport featured in Caddyshack? Is it baseball, tennis, golf, or basketball? What is the main sport featured in Caddyshack? Baseball, tennis, golf, or basketball? Oh, folks, Jay would be getting this right away. You got to know it is golf. Bunny, it may have been the buffering, because when it tries to do that and like you're on a phone, it won't always be able to bring you back into the stream right away. But needless to say, Bunny got that one right first, half a point. Nancy and Allie Towel both picking up half a point as well. Excellent job. Where's Allie Towel? Pretty easy questions, but you at least got to know the movie. All right, next question. Who was the film's director known for comedies like Groundhog Day? Who directed Caddyshack and was known for films like Groundhog Day? Was it Harold Ramis, John Landis, Rob Reiner, or Ivan Reitman? Was it Harold Ramis, John Landis, Rob Reiner, or Ivan Reitman? I'm going to guess Ramis or Landis. I'm going to go John Landis. Nope, it was Ramis. I should have got my first one. Bunny jumping ahead, picking up 2 points. Excellent job, Bunny. Nancy, good guess. I could have seen it being Rob Reiner as well. Good guess. And Allie and Rue, they might be having some buffering issues. I'm having my own buffering issues, but we're almost done. Last category. That was a tough one. Jay plays head games. Yeah, he makes us do the category and then leaves. Allie and Bossy Texas Chickabella both pick up a full point. Excellent job, Allie. Excellent job, Bossy Texas Chickabella. All right, welcome back, Bossy Texas Chickabella. You are bosses, you are from Texas, and you are chicks. Next question. Which character was portrayed by Chevy Chase in the movie Caddyshack? What character was portrayed by Chevy Chase in the movie Caddyshack? Judge Smales, Danny Noonan, Carl Speckler, Ty Webb. Noonan! I think that's from Seinfeld, actually. I just want to go Danny Noonan because it sounds like the right answer, but I have no idea. Show me Danny Noonan. No, it was Ty Webb, ladies and gentlemen. If you knew that Chevy Chase played Ty Webb in Caddyshack, you got the answer right. It was number 4. Allie and Rue picking up 2 full points. Everyone thought it was Carl Speckler. I thought it was Danny Noonan. But the actual answer, Allie and Rue nailing it, Ty Webb. Good job, folks. That was a tough one. I got 2 wrong in a row. Nancy from the 508 picking up a point as well, a full point. Oh, wow, this is very close. Bunny Towel and Nancy Towel and Towel are all close. Allie Towel's charging. Thank goodness she got here late. We all would have been screwed. Allie will play again tomorrow, by the way. I'm going to end the stream, 1, because I want to go get lunch, and 2, because I set it up wrong. So, as you know, the buffering is annoying. Next question. What character's rebellious behavior leads to an iconic scene involving a gopher? Danny Noonan, Al Cervic, Ty Webb, Carl Speckler. Which character's rebellious behavior leads to an iconic scene involving a gopher? Danny Noonan, Al Cervic, Ty Webb, Carl Speckler. It's whoever was played by Rodney Dangerfield, I think. Show me Danny Noonan. Oh, it was Carl Speckler. It was Carl Speckler. Whoever guessed Carl Speckler, go with it again. Bunny comes in and picks up a huge 2 points, ladies and gentlemen. Oh, goodness. As we charge into the final question after this, Bunny just comes in, steals 2 points off the board. Allie and Rue grabbing a full point. Nancy Towel picking up a full point. Oh, this is close. This could all come down to the final question. Let me just tell you right now. Wow. Haven't seen a finish like this in quite some time on Towel Trivia. Nancy, you are holding on. All comes down to this final question. Good guess, Bossy. Texas Chicken Bella. It was Carl Speckler, though. Final question of the day. Which actor played the role of the wealthy and obnoxious club member? Which actor played the role of the wealthy and obnoxious club member? Was it Bill Murray, Ted Knight, Rodney Dangerfield, or Michael O'Keefe? Bill Murray, Ted Knight, Rodney Dangerfield, or Michael O'Keefe? Show me Rodney Dangerfield. I got it. Oh, that was big. Who's going to get number 3 first? It all comes down to this. Oh, these are intense moments, ladies and gentlemen. Intense moments. Allie gets it wrong. It all comes down to who's it going to be? Is it going to be Nancy or Bunny? Allie, you can't guess twice. Is it going to be Nancy or Bunny? Oh, goodness. Bunny takes the risk, grabs the full point. Is Nancy going to come in and get it right? Nancy comes in and gets it right. Oh, goodness, we had a photo finish. Oh, ladies and gentlemen, we had a photo finish. I've never seen anything like it in my entire life. Oh, goodness. Allie, you changed your answer. All right, Allie, you can have half a point for that. Oh, goodness. Oh, goodness gracious. Look at this scoreboard. I can't wait to bring Pete Bunny Towel over here to announce this. Oh, wow. What a day. Oh, okay, Allie, you're giving up your half a point? Okay, that's fine. You don't move position on the board anyway. Are you ready to see this score reveal? Pete Bunny Towel, take a look at this score. I'm going to show it to Pete first. Look at this scoreboard, Pete. Oh, goodness. He said the same thing as me. Are you ready for this, Little Towels? Are you ready for this? There it is. We have 2 champions today. It is a tie. It came down to the last question. Instead, they share the crown. Excellent job, Nancy and Bunny Towel. First place, today's round of towel trivia. Excellent job to both of you. Pete Bunny Towel is thrilled. He is singing your praises. Dual champions, Nancy and Bunny Towel, down to the last question. 16 points each. Nancy said Bunny, and Bunny says, what the heck? That was good competition. You both, Bunny puts a bunch of hearts for Nancy. You both did so well. That was great. Allie says, good job, Nancy and Bunny Towel. And Pete Bunny Towel shares in that excitement. That was fun. That really was down to the wire. Now, mind you, if I had gotten that wrong, anything could have happened. It could have been anyone's game. But I got it right, which meant that Bunny and Nancy, depending on the order there, Nancy held her lead. And she played tactically, she played carefully, and it was fun, Nancy. And you and Bunny Towel get to wear the crown. Bunny says, my towel fiber nerves are a wreck. That was really fun, though. It was informative. We did 4 categories today. You folks got a lot of questions right. We learned a lot. And as you can see, wearing the crown, heading into tomorrow. It is always fun. Wearing the crown, heading into Monday. We'll start tomorrow in the morning. I think I have something in the afternoon, so we won't go long tomorrow either. Excellent job. Nancy and Bunny Towel tied in first place. In second place, Little Towels, right behind Nancy and Bunny. I had to put all my effort in. I could not do it, though. I could not surpass the champions. Nancy says she learned a lot. I did as well. Bunny and Nancy are sharing the crown. Yes, they are. Yeah, Jay may have had internet issues, though, because I didn't fix the stream or whatnot. But Jay had fun. We had a good time. But needless to say, hold on, I'm not number 1. I'm in second place. I'm a Little Towel, 14 points. Excellent job, Little Towel. Thank you, Pete Bunny Towel. Second place. Now, because of a quirk in the scoring system, ladies and gentlemen, we just saw what might have been one of the most impressive performances of all time. Allie, who joined more than halfway through the game, just stormed out of nowhere and takes a podium position. Allie, Rue, and Toffee Towel 8 points. Third place, excellent job. Allie would have missed the podium if Nancy and Bunny didn't tie, but there you go. Allie, Rue, and Toffee Towel regain their honor, come in third place, and that rounds out our podium. Nancy and Bunny Towel wearing the crown. Towel with 14 behind Nancy and Bunny, who have 16, and Allie Towel with 8. But I would be remiss if we also didn't talk about the excellent performance of Bossy Texas Chickabella, who came in at the very end of the game and serendipitously enough got 4 points, putting themselves in 4th place. You love to see it, ladies and gentlemen. You absolutely love to see it. Woohoo indeed, says Allie and Brew and Toffee Towel. But yes, in 4th place, 4 points, Bossy Texas Chickabella. They're bosses. They're from Texas. You got to deal with it. You know what it is. You'll figure it out. 4th place, 4 points. Excellent job. In 5th place, Shannon was with us again today playing. That was really fun. Great job, Shannon. You did excellent. You are a Super Towel. 3.5 points. Pete Bunny Towel is very, very proud of you. And Pete Bunny Towel is, of course, proud of all of the winners. He's sitting over here. He's very hungry. He wants to know if I'm going to get him lettuce. I said I'll think about taking him to get a cheeseburger, and then he can have the lettuce. We have to run errands first, though. I'm sorry, Pete. I got to vacuum the car because I just want to vacuum it. Then I found some papers in the car from law school that I want to sort through, some pictures and stuff. And then I want to put gas in the car. So I have 3 things I have to accomplish today, okay? So we can get ready for the week. I have to drive tomorrow to an appointment. I'm a little towel, okay? What does this have to do with the score? Nothing really. I'm just telling you, you know, Pete Bunny Towel and I are talking, and he's Pete Bunny Towel. But yes, in 6th place, we have a 2-way tie. He may have ghosted us. You interrupted my orchard care video, but still fun. Oh, Allie, we'll have to do orchards as a category tomorrow. Definitely remind me, you, Rue, and Toffee Towel. I would love to do orchids as a category tomorrow. In 6th place, though, we have a 2-way tie. Mr. Cossie G and J, 3 points apiece. Excellent job to both of you. Pete Bunny Towel is over here rocking out to his music. He says you both did a great job. Welcome to the stream, Mr. Cossie G. Thanks for playing. Number 7, in 7th place. You can call them Captain of the Good Ship, Bodie McBoatface. They are the lovable Nunya. 1.5 points. They hung out with us today. We had a Orchids. It's pronounced Orchids. Thank you for that, Allie and Rue. And Toffee Towel. 7th place, Nunya Towel. 1.5 points. Pete Bunny Towel loves Nunya very much. He's a Nunya Towel. In 8th place, ladies and gentlemen, what an excellent job by one of our first-time player. Brian takes in the position of honor, coming in with 0.5 point. Excellent job, Brian. We were happy to have you play again with us anytime. Pete Bunny Towel had a wonderful time with you all. Now, you know how we're going to end. I have the link literally ready, okay? I'll put the scores up in a second. I literally have the link ready from Bossy Texas Chickabella. Yes, if you've never heard this song before, ladies and gentlemen, this is the Towel Trivia song. Well, hopefully, maybe I'll work on it. Bossy Texas Chick might have to help me. We're going to have a new version soon. Yes, this is the Towel Trivia song. It's really fun to listen to. Some of you are in it. Hopefully my computer will be able to get through it, and Pete Bunny Towel and I are going to hang out with you as we listen to this song. It's loading. It's loading. Oh, and those are the categories. I spelled Iroquois wrong, but Austin Powers, Habits of the Iroquois, Christmas Rap, and then Orchids. Can I put Orchids here? Orchids. I think that's how you spell it. All right. So there are your scores, ladies and gentlemen. There are your scores. All right. Now, let us bring this up. All right, let me shrink the scores because I had to go down and get the link for the song. And now let us listen to Bossy Texas Chick and Bella. Bella's the composer with Towel Trivia's theme song. I love it very much. Look at that's me and Peep hanging out.
Welcome to Grant's Towel Trivia. All you knowledge junkies, but grab your wrench and your towel. More fun than a barrel of monkeys. Grant and his cigar is on the screen with a smile. He's got lots of questions, so we'll be here a while. All of us contribute in our own special way, and it doesn't matter who wins at the end of the day. We're the Towel community, and we won't stuff. Jeff's waiting on the clue. Claudia's got the answers, but Bunny does too. Lydia's sharp as a tack. Death fodder's on the ball. Sometimes we grumble when our scores get called. Now Harvard Yard keeps guessing answers that ain't up on the board. Don't ask me how, but she just scored. Bossy Texas Chicken Bell are last place again. They're always at the bottom, but one day they will win. That's alright. That's an ain't a Every day's a new adventure in Towel Trivia Town. KR's not guilty, but that won't get us down. From the brightest to the struggling, we all play along in this corner of the internet where we all belong. So here's to all the players and the hosts so fine in this little slice of heaven where we all do shine. Towel Trivia time. Towel Trivia. Welcome to the Grant Smith Ellis Show. When you know you know. Towel Pride.
Love it. Pete Bunny Towel is so happy. He loves that song. All right, so Towel has his technical notes, by the way, for fixing the stream. I actually just did some research over the course of this stream, so I know what to do tomorrow. Sorry about all the buffering. I will reduce that quality a lot. It won't really impact your viewing experience unless you have a 4K TV, in which case it will. But if you want to watch Towel in 4K, we're a few years away from that. Yeah, it's surprising actually how much system resources you need to broadcast in 4K or even like 2K. It's very hard to do. All right, my name is Grant Smith Ellis. Thank you so much for playing trivia with me today. Thank you so much for watching. Number of things that I'll go through. One, if you like this stream, there's a number of ways you can support it. You can subscribe to the channel, tell folks about the channel, tell them to come play trivia with us, learn about the different aspects of the system, the justice system, our government. Otherwise, it's really fun. This is a public information service. It's designed to educate, inform, and entertain the wider public, such as to engender cogent public discourse and ward off the usurpation of our representative forms of government worldwide. Now, there's a lot of different ways you can support. God bless you to the person who sent over $5 today for Towel Pizza. I will definitely get some lunch on my way home. LS, God bless you, my friend. Thank you for spending some time with us today. And let me go over and get these links. If you liked this stream today, if you want to support Little Towel, keep me going through the holiday season. God knows I'm probably not going to get any help from my family. You can find those donation links below. You can also find me at Venmo, where I'm Grant E1. You'll see the little picture of the Elmo doll in honor of my friend Elmo, who was a service member that passed away. That's how you know it's me, and every time something is money sign Grant Smith Ellis, the PayPal is paypal.me/Grant Ellis. All right, so I want to say also hello to folks in the chat before we get out of here. Hopefully this will not overwhelm my computer. LS, Allie, Bunny, Nancy from the 508, Bossy, Texas Chicken, and Bella, and LS, of course. It was great to see you. Jay. Who else did we have here? Christina was here. Great to see you, my friend. Pugs Over Drugs 2025. Gotta love pugs. I love it very much. Who else do we have here? We had, Nunya, that's right. I also will try to actually clean out my computer fan. That might help with some of the bitrate issues. God bless you, Bossy Texas Chicken Bella. Thank you for supporting Towel Stream. Mr. Cossie G, thank you so much for playing with us today. We had a great time. See, look at all these Towel friends hanging out. We had a good time today. I can't even go back all the way. But thank you so much for playing. We had a great time. I enjoyed it. Pete Bunny Towel enjoyed it. Go Patriots, says Nancy. Yes, absolutely. Go Pats. All right, so here's how we'll round out. I like to end the stream the same way in every day. And today, if you fought through the buffering, because I tried to stream in 4K, you know what I'm going to say. You know I'm gonna say there's a way you can pay it forward. There's a way that you can show appreciation that doesn't involve subscribing or anything like that. You can look for reasons to do small acts of service for the folks around you. All right. One of the best ways to do that, in my opinion, is to donate to our homeless veterans. There should not be a single veteran in the United States. Veterans, we will do so, and I believe that's extremely important. They served our country. They protected us. Now it's time for us to help them, especially during these difficult times and in the winter months. Another way you can help, though, is what if you like animals? Like Pete Bunny Towel. He's almost an animal. He tells me he is an animal. He refuses to be told otherwise. You are fabric, though. Yeah, but he's a towel, he says. You can donate to animal shelters run by veterans. Look, you can help veterans. You can help animals. Everybody wins. Now, what if you want to just donate to animals in general? Well, look for a local animal shelter. Maybe the help if you want to help populations experiencing homelessness. You can donate to the Big Issue. Way to do so if you okay, that's the Big Issue. But there's other ways to do so. Tomato plants, like Francis Futrell did one time, and have them designated honorary towels forevermore. Yes, in that way, ladies and gentlemen, I think it's possible we can change the current, expanding and demonstrating our capacity to engage in small acts of service rooted in unconditional love. And by doing so, may we find our towel eudaimonia, or summum bonum, our greatest good in the ancient Greek or Latin, respectively. And in that way as well, let those small acts of service and kindness ripple outwards, such as to bring about a new digital epic defined by Aquarius the water bearer standing tall and carrying a towel. I believe it's possible because of you all, and I'm grateful to have been on this journey with you today. My name is Grant Smith Ellis. God bless each and every one of you on this Sunday, a rare Towel Sunday stream. Maybe that's why the buffering happened. No Towel Sunday streams. No, I got it fixed already, but it won't actually refresh until next stream, so thank you for bearing with me. Thank you for playing trivia with me today. Towel Friends on the X, you know you got a few minutes extra at the beginning, so I'm going to give Towel Friends on the YouTube a few minutes extra at the end. God bless you, Towel Friends on the X. Go enjoy this Sunday. If it's raining, if it's snowing, go Patriots. Enjoy the football. I'll be watching after I get my errands done, and hopefully I can eat a towel snack once I get home. My name is Grant Smith Ellis. God bless each and every one of you. Thanks for watching. Until next time, youtube.com/@GrantSmithEllis or x.com/GrantSmithEllis. Join me anytime in the discussion. Towel loves you very much. So does Pete Bunny Towel, even though he hates the commies. Towel Friends on the YouTube. Thank you so much for bearing with me today. Technical hiccups and otherwise. It wasn't really a technical hiccup. It was more, I think, a lesson in the fact that there's a certain limit to how good of a quality stream I can do. But it's really immaterial. The human eye can't see the difference between 1080p and 4K. I could go down to 720p or even lower if I needed to and really condense things if I want to. So don't worry about that. Thank you for bearing with me. I'm a technical towel, and my proficiency is such that I will be able to make things a little bit smoother tomorrow. I'll set up the stream for tomorrow at some point. It's got to be early in the morning. Got things to do in the afternoon. Thank you again. People pop in. We haven't done a long stream in a while because there's not a lot of trials going on. But we're going to continue to do our sporadic updates heading into the holiday season. It is Thanksgiving this week, so if you need me or if you ever want to talk to someone, just reach out. You know how to find me. My name, GrantSmithEllis@gmail. You can reach out on X. You can DM me. Any way you want to reach out. You're not alone this holiday season, and I'll make sure of it. But yes, Towel loves you all so much. Please enjoy this blessed Sunday, as Jay said, and go Patriots, as Nancy said to sign off one more time. My name is Grant Smith Ellis. I'm hanging with Pete Bunny Towel. We love you all very much, and we'll see you tomorrow, Monday, November 24th, bright and early. I'll put up the stream link in just a few minutes here, and I'm looking forward to it. God bless you, Towel friends. Until next time, be well. Enjoy the day.